Do you and each of you swear that you will well and truly try the issue joined between the state of Wisconsin, the plaintiff, and Mark Jensen, the defendant, and unless discharged by the court, a true verdict give according to the evidence given in court, so help you God?
I do. Please be seated.
Good morning, everyone.
Good morning.
We're going to start the trial now, and before it begins, I want to give you a few instructions that I hope will help you better understand your functions as jurors and how you ought to conduct yourselves during the trial. Your duty will be to decide this case based only on the evidence presented and the law as given to you by the court. Do not let any personal feelings of bias or prejudice about such things as race, religion, national origin, sex, or age affect your deliberations. Do not begin your deliberations and discussion of the case until all of the evidence has been presented and I have instructed you regarding our law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. You may be excused from the courtroom when it is necessary for me to hear legal arguments from the lawyers. Now, you're here to decide the case, what the facts are, and ultimately to decide, when instructed about what the law says, decide whether the defendant is innocent or guilty. And I don't have any role at all in what the facts are. That's your decision alone. My function is to keep order in the court and to make sure that the rules are followed, both with respect to evidence and with respect to the presentation of evidence. So sometimes the lawyers are going to disagree about whether something's admissible evidence or not. And that is, they may get into a dispute about it, that I have to consider the legal positions and make a decision on it. And those are things you don't have to concern yourself with, because you are only to decide, you are to decide this case only on the evidence which is admissible under our law. So that at those times when I'm having discussions about what the whether evidence should be received or should not be received, you may be excluded from the courtroom. So you're not being deprived of something that you need to know, because if I sustain the objection, it's something that is not admissible, and there's reasons for that. These are not rules that just were developed or are personal of mine. These are rules that have been developed over hundreds of years to make sure that a fair decision is reached in the case. So if I sustain the objection, that means that the evidence is not at the level that we consider something that can be used in the court. If I overrule an objection, that doesn't mean, well, I'll get into that in a little bit, but basically that explains why we might have discussions which may be extended outside your presence. So don't feel that you're being deprived of something at that particular time. If during the case you come in contact with the parties, the lawyers or witnesses, do not speak with them. For their part, they will not contact or speak with you at all. And if anyone attempts to speak to you concerning the case, please report that either to me or to the bailiffs immediately. Do not listen to any conversation about the case. There are a number of representatives from the media covering the trial. As was discussed earlier, what the media may report is not of the standard necessary for jury use in deciding the great issues which will be presented to you in this case. And for that reason, you must not read any newspaper reports or listen to any news accounts on radio or television about this trial. Do not watch or listen to any newscasts on television or radio which originate from Milwaukee, Kenosha, Whitewater, or Lake Geneva for the duration of this trial. Do not read the Kenosha News, the Milwaukee Journal-Sentinel, the Janesville Gazette, the Week, the Midweek, or the Racine Journal-Times, or any article in any other publication or anywhere else that pertains to this case. Do not read anything at all on the internet which pertains to this case. Do not investigate this case on your own or visit the scene. Do not engage in any experimentation or research relating to issues, facts, or persons involved in this case. Do not consult dictionaries, computers, websites, or other reference materials for any additional information regarding this case or any issues which may pertain to it. Anything that you see or hear outside this courtroom is not evidence. You are to decide the case solely on the evidence offered and received at this trial. Television and photography will be occurring during this trial, but under no circumstances will televising or photographing of jury members be permitted. and you will never be pictured in any image which is broadcast or telecast because none will be acquired. For those who may be interested, I have requested that the media make available to you after the trial is over access to all of the media accounts which will be telecast during the trial. It is critically important to the fairness of this trial that you adhere to the order that you not read, watch, or listen to any account of these proceedings. You must understand that a violation of this order will have serious repercussions, both for the integrity of the trial and for anyone who would violate the court's order. Your ability to remain without a sequestration order, which would require that you all be held in a hotel when you're not in session here for the duration of the trial, will depend upon your compliance with this order. And you must understand that any violation will be dealt with as a contempt of the court. Now, evidence is defined first as the sworn testimony of witnesses both on direct and cross-examination, regardless of the party who calls the witness. Second, any exhibits which have been received, whether or not they accompany you to the jury room. And third, any facts which the lawyers have agreed or stipulated or which I direct you to find. Attorneys for each side have the right and duty to object to what they feel are improper questions asked of witnesses and to the receipt of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing testimony or other evidence to be received over objection, I do not mean to indicate any opinion as to the weight of the evidence. You are the sole judges of the believability of the witnesses and of the weight of the evidence. You are not required to make notes during the giving of evidence in this case. But you may do so if you wish. You will be permitted to make notes during the giving of evidence, but not during opening or closing statements. You'll be provided by the bailiffs with materials. In taking notes, you must take care that it does not distract you from carefully listening to and
What's going on, everybody?
witnesses.
Welcome
You
to
may
the
use your notes
stream.
during your deliberations to refresh your
Make sure you guys hit that
recollections.
thumbs up.
Otherwise, you should keep them
Share the
confidential.
stream out.
After the trial, your notes will be collected by the bailiffs and they
So
will
we
be
ended up
destroyed.
finding the
You
original
will not have a
opening
copy of the written
statements
transcript of the trial
from the
testimony available
2008,
for use during your
Mark
deliberations.
Jensen murder
You should
trial.
pay careful attention to
So
all
we're
of
going
the
to take a look
testimony
at the
because you will be
prosecution's opening
required to rely
statements today
primarily
and
on your
the
memory of the
defense
evidence and the
attorney's
testimony
opening
introduced
statements
during
from the
this trial.
2008 trial.
It is your duty as jurors to scrutinize and to weigh the
Kind of give you guys a
testimony of the
sample of
witnesses
what we
and
might
determine the effect of the
expect
evidence as a
during
whole.
opening
You are the sole
statements
judges of the
for
credibility,
the
that is, the
retrial of
believability
Mark
of the
Jensen.
witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness is interested or disinterested in the outcome of this trial, the witness's conduct, appearance, and demeanor on the witness stand, clarity or the lack of clarity of the witness's recollections, the opportunity that the witness had to observe and know the matters and things about which the testimony is given, the reasonableness of the witness's testimony, the witness's apparent intelligence, bias or prejudice, if any, is shown, possible motives to falsify, and all other facts and circumstances appearing during the trial which tend either to support or to discredit the witness's testimony, and then give to the testimony of each witness just such weight and credit as you believe it is fairly entitled to receive. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and experience. In your everyday lives, you decide for yourself the reliability of things said to you by others, and you should do the same thing here. Now, the information in this case charges that on the 3rd of December of 1998 at the village of Pleasant Prairie in Kenosha County of this state, the defendant caused the death of Julie Jensen with intent to kill her. To this charge and the information, the defendant has entered a plea of not guilty, which is a demand that every material allegation of the information be proved beyond a reasonable doubt. Intentional homicide of the first degree is defined in the criminal code as being committed by one who causes the death of another human being with intent to kill that person or another. Before the defendant may be found guilty of intentional homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant caused the death of Julie Jensen. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill Julie Jensen. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause her death. While the law requires that the defendant have acted with intent to kill, it does not require that the intent have existed for any particular length of time before the act was committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including at the instant of the act, the instant of before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to determine
What is up,
intent.
April?
Intent
How you
must be
doing?
found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and
Make sure you guys
circumstances
like
in
this
this
stream
case
and
which
share
bear
it out.
upon intent.
So we're
Intent should
watching
not be confused with
2008.
motive.
Jensen
Proof of
trial
intent
opening
is necessary
statements.
to
So we're going
conviction.
to watch the
Proof of
prosecution's
motive
opening
is not.
and
Motive refers
the
to a
defense
person's reason
opening
for doing
statements from
something.
the original 2008
While
trial.
motive may be shown as a
Gonna give you
circumstance
guys,
to aid in
little
establishing the
look
guilt
at
of the
what
defendant,
to possibly
the state
expect
is not
for opening
required to prove
statements that are
motive on the
expected to
part of a
start
defendant
tomorrow.
in order to convict him.
The
Evidence of
original
motive
judge,
by itself does not establish
Bruce
guilt.
Schrader,
You should give it
you guys
the
know him
weight
as the
you
Kyle
believe it
Rittenhouse
deserves
judge,
under all of the
or
circumstances.
Kyle Rittenhouse's grandpa.
In reaching your verdict, examine the evidence with the utmost care and caution. Act
Yes,
with judgment,
rocking chair
reason,
is
and
back.
prudence. The defendant is not required to prove his innocence.
So if you guys do
The law
remember during
presumes
the
every
Kyle
person
Rittenhouse
charged with the
trial,
commission of a crime to be innocent.
Judge
This
Schrader
presumption
had kind of
requires a
a
finding
demeanor
of not
about
guilty,
him.
unless in your deliberations you find that it is
there was a lot of
overcome
talk that,
by
you know,
evidence
this
which
is how he
satisfies
is
you
as a
beyond a
judge.
reasonable doubt
And
that the defendant is guilty.
the way he's
The
talking here
burden
in
of
the Jensen
establishing every
trial,
fact necessary to
very,
constitute
very
guilt
similar to how
is
you
upon
saw
the
him in the
state.
Kyle Rittenhouse
Before you
trial.
can return a verdict of guilty, the evidence
he
must
has
satisfy
been
you
the
beyond a
same
reasonable doubt that the
Robotic
defendant is guilty.
judge for
If you can
decades.
reconcile the evidence upon any reasonable hypothesis consistent with the innocence
So
of the
right now during
defendant,
this part,
then you must do
you know,
so
he's
and find him not
addressing
guilty.
the jury.
The term reasonable
And,
doubt means a
after he's
doubt
done
based
with
upon
his
reason and
basic
common
speech,
sense.
We're going to
It
hear
is a doubt
the
for which a reason can be
prosecution's
given,
opening.
arising from a fair and rational consideration of the evidence or lack of
It's a
evidence.
little over
It
an
means
hour
such a
long,
doubt
so once
as would
that's
cause
done,
a person of ordinary
we'll play
prudence
the
to pause or
defense
hesitate
opening.
when called upon to act.
Again,
in the
kind of give you
most
guys a little
important affairs
first-hand
of
look
life.
at maybe
A
what we can
reasonable doubt
expect
is not
for
a doubt which
tomorrow.
is based upon mere guesswork or
Obviously, during this
speculation.
trial, they're
A
probably
doubt which
going to
arises
refer
merely from
to the
sympathy or
letter.
from fear to return a
That
verdict of
is
guilt
not allowed
is
to
not
be
a reasonable
referred
doubt.
to
A reasonable
in
doubt
the
is not a
new
doubt such as may
retrial
be
of Mark
used to
Jensen.
escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. Search for the truth. The lawyers will now make their opening statements. Mr. Jamboys will make an opening statement on behalf of the state, and then we'll take a break. And after that, Mr. Albee will address you on behalf of the defendant, and then I think at that time we'll probably take a lunch break. Keep in mind that the purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence, and for that reason, as I indicated before, taking of notes is not permitted during opening statements. With that, Mr. Jamboys, if you're prepared, you may make your opening statement.
Thank you, Your Honor. Good morning, ladies and gentlemen.
Yeah, I mean, he's probably like this in real life. I'm gonna just mute these commercials. These commercials are like, I don't know, 15 seconds long a piece. They're kind of long. Sorry, nothing we can do. This is very old archived footage that we're watching. We're going to do our best to get through these. We can't skip over them, unfortunately.
In your search for the truth in this case, you're going to be hearing evidence that I guess will be broken down into, from the state's perspective, be broken down into chapters. And the first
I'm going to kind of
chapter
talk
is going
over
to
this a
be
little bit just
presenting
to
evidence
avoid some
about
copyright
what
stuff,
was
but
going on in Julie's life, in Julie's mind, from
kind of
Julie's
do some live
perspective
reactions. We'll
in the
pause. We'll
last
talk a
weeks,
little bit
months, days, and hours of her life.
just to avoid copyright. We're getting whacked
On the
on
morning
copyright
of
stuff with some
December
of this old
2nd,
archive footage.
1998, Julie Jensen was very ill. She was very sick, and you're going to hear from expert testimony about the first stages and the second stage and the third stage of ethylene glycol poisoning. It's all on the internet that her husband, Mark Jensen, was consulting in looking for ways to murder his wife in the weeks and months preceding her death. So at the time of on December 2nd, 1998, as Julie Jensen lay in her bed, suffering, desperately ill, her husband, Mark Jensen, knew exactly why she was sick, why she was ill, why she was suffering. As he lay next to her that night in the marital bed on the evening of December 3rd, 1998, as she was gasping breath, raspy, and barely able to breathe, Mark Jensen lay there next to her, knowing what she was going through because he'd read all about it on the internet in the months preceding her death. But Julie Jensen didn't know that on the morning of December 2nd, 1998. And even though she was desperately ill, even though she was terribly sick, she was happy. She was happier than she'd been in a long time. And you might wonder, why was Julie Jensen happy on this morning of December 2nd, 1998, when she was laying there unknowingly dying? Well, even though she was terribly sick, even though she was physically uncomfortable and in some measure of agony, Julie was finally happy because her husband was finally showing her what she'd wanted all along. Julie viewed herself as a loving mother and as a loving wife, and all she wanted was some attention from her husband. She wanted her husband to love her and to care about her. And over the preceding several weeks and few months, she really wasn't getting any of that from her husband. He was being critical and cold, and in fact, she even thought that he was trying to poison her. She had come to suspect that for a variety of reasons, but she wasn't sure. And imagine, if you will, I mean, you folks know people that are married, have been married for years. Imagine how difficult it would be for any one of the people that you know who is married to come to the conclusion, to wrestle with even the idea that your spouse is trying to poison you. So Julie was wrestling with that, and it was hard for her to believe that her husband was trying to poison her. She thought maybe, she was seeing these signs, these evidence around the house and on the computer. She would see him working on the computer, and she'd kind of suspect that maybe he was trying to look for ways to kill her, but maybe he recognized that they were about to divorce, and he was looking for ways to make her look like she was crazy so that she'd get fearful, take the children, and tell the police and tell other people that her husband was trying to kill her, and then he'd have a perfectly reasonable explanation and make her look stupid, and then he'd be able to get the children. So she was wrestling with this in the weeks and the months preceding her death. So she didn't have that many friends, but she talked to the people whom she could talk to. She talked to her next door neighbor, Ted Voigt, and you're going to hear from Ted Voigt, and you're going to hear from his wife, Mrs. Voigt. And these are among Julie's closest confidants, particularly Mr. Voigt. She would confide in him, and he would offer her the use
I think that's
of
that
their
Thaddeus
they had a lake
person
home
that
somewhere else.
yesterday
he'd offer her,
weren't
let
sure
her
how to
take the
pronounce his
children and
name.
go there. But she was
Sounds like it's
concerned that, first of all, Mark was very powerful. She perceived Mark as being very powerful. She believed that if she left Mark, she'd end up losing her children, and she also had no alternative means of support. So what was she to do? So she continued to talk to Mr. Voigt. She talked to a teacher, Teresa DeFazio. She even talked to her best friend, and her best friend, ironically, is Mark Jensen's sister, Laura Koster. And she confided in Mark Jensen's sister that she believed her husband, Laura Koster's brother, was trying to kill her. She didn't know what to do. She talked to Teresa DeFazio, and Teresa DeFazio was her son David's third grade teacher. And she talked to Teresa DeFazio quite a bit. And at one point she told Teresa DeFazio, after there'd been a parent-teacher conference, and Teresa DeFazio asked how it had gone, and Julie told her, was quiet, and then after a moment or two, she said,
if my significant other was trying to kill me, or
and
I thought
Teresa
they were,
DeFazio
I'd be
said,
out.
well, why would you think such a serious, such a terrible
I'd move
thing?
out
And
fast.
then Julie laid out her concerns to Teresa DeFazio and said, well, maybe she'd seen this thing. He was trying to get, he'd written down syringe and some other words like that, and made a list of things that they would never normally need.
Jamboy has said in the years following this
maybe
case, knowing
Mark's
that
got
this
a
was
drug
coming back to
issue
trial,
that she didn't know about. Or maybe he's just trying to make her look crazy or drive her crazy. She just didn't know.
Piece of evidence
and
that
Mrs. DeFazio said she
convicted,
should also talk to the police.
Mark Jensen.
So Julie did that.
The state is confident they have enough of damning
the
evidence.
police.
There's also been some jury interviews
Pleasant Prairie police officers
where
because
jurors
they've
have
been
also
to the
said
house
that
on
the
numerous
letter
occasions over the
didn't make
preceding
that
years
big of a
because there had
difference in their
been
decision from the original 2008
apparent
trial.
history of harassment. And initially, both Julie and
So
Julie
they
and
talked
the
about
police
his internet
thought that the
searches,
source of this initial
on how to unalive
harassment
somebody
was a
and
person
things
named
like
Perry
that.
Tarica.
And that was very
And you
damning
heard
to them.
testimony that Julie Jensen had had a brief affair a number of years earlier in her marriage, during the course of her marriage to Mark Jensen. And this affair was with Perry Tarica. Somehow or other, Mark Jensen found out about the affair, and it was broke off very quickly. I mean, it was only a day or two, a few days long. But after the affair had been broken off, after Mark Jensen found out about the affair, they were getting these series of hang-up phone calls, and there were these photos being left around the house, and according to Mark Jensen, they were being left at his office or mailed to him at his office. And these photographs are all, I guess, adult pornography, you could call them. They presented pictures of women either performing fellatio or about to perform fellatio. They showed men with erect penises with a woman's face right in close proximity. Those are the kind of photos that are being left around the house in the years preceding Julie Jensen's death. And the police investigated these things, and they believed Perry Tarica was responsible, and they talked to Perry Tarica. But then at some point during the course of this investigation, they discovered that Perry Tarica had moved to New York. And there was no way that he was coming around here moving their furniture.
This topic in this original trial was a big contentious argument
Mr. Jensen's
between the attorneys in front of Judge Schrader.
There's simply no way that
there are some old clips that we found of the argument on whether or not to allow these photographs.
So they put a trap and trace on the phone call with Mrs. Jensen, with Julie Jensen's permission. They tell Julie about it, and they told her, "Don't tell Mark. We suspect Mark is doing this, so don't tell Mark." And then during the trap and trace, there'd be no hang-up phone calls during the trap and trace period. They'd be on for a week, and they were getting hang-up phone calls on a regular basis. And then during the week that there was a trap and trace, there'd be no phone calls. And Officer Cosman would come back and ask Julie, "Well, there were no phone calls. Did you tell Mark about this?" And Julie would concede yes, she had told Mark about the trap and trace because she couldn't keep any secrets from him after she'd cheated on him like that. She felt desperately guilty about having cheated on him. So she would not keep any secrets. So during this entire investigative phase, in fact, at one point, Mark and Julie had hired a defense, or had hired an investigator to to perform surveillance at the house and at Mr. Jensen's place of work. And of course, during the surveillance, no photos were left. Well, again, it was Mark Jensen that was paying for that. Now,
all right, once again, sorry about the ads. This is archived footage that we found. We cannot skip through these particular ads, unfortunately. So opening statements expected to start tomorrow in the Mark Jensen retrial. Jensen was originally convicted in 2008 for murdering his wife with antifreeze. And we are playing some archived footage that should kind of give you an idea of what to expect in opening statements that are expected to start tomorrow. So we're going to play the prosecutions and the defense from the original 2008 trial.
So Julie had this prior contact with Officer Cosman, and she called and left a message for Police Officer Ron Cosman and Ron Cosman wasn't there.
As you guys are coming in, be sure to like the
And-
stream, share it out.
And this was right around November
Once
21st, and we
the
know this
trial
because
starts, we will be
then what
live
Julie
streaming
did
it.
was
They were only
she took a
allowing
camera
still
and she
photography
photographed
during
some entries
jury selection
on
yesterday
Mark
and
Jensen's
the
day
remainder
planner.
of today.
and she wrote this letter.
There are
Pleasant
only
Prairie
about
Police
40
Department,
jurors
Ron
left.
Cosman or
in
Detective
voir dire.
Ratzenberg. She
We
has
do have another
Ratzenberg. His name is actually
70 on
Ratzenberg.
standby in case most of those
I
jurors
took this
get
picture
dismissed
and
today.
am writing this on Saturday, November 21st, 1998 at 7 a.m. This quote, list, unquote, was in my husband's daily business daily planner, not meant for me to see. I don't know what it means, but if anything happens to me, he would be my first suspect. Our relationship has deteriorated to the polite, superficial. I know he's never forgiven me for the brief affair I had with that creep 7 years ago. Mark lives for work and the kids. He's an avid surfer of the internet.
All right,
Anyway,
so here's the letter.
I do not smoke or drink.
So
My
they actually
mother
read
was
this
an
to the jury
alcoholic,
back then.
so I limit
this
my
letter will
drinking
not be
to one or
allowed
two
in
a
the
week.
retrial.
Mark wants me to drink more with him in the evenings. I don't. I would never take my life because of my kids. They are everything to me. I regularly take Tylenol and multivitamins, occasionally take OTC stuff for colds, Zantac or Imodium, have one prescription for migraine tablets, which Mark used more than I. I pray I'm wrong and nothing happens. But I am suspicious of Mark's suspicious behaviors and
See, this
fear
is
for my
interesting
early
because
demise.
it's not only the
However,
antifreeze,
I will not leave David
but
and
he's
Douglas,
accused of giving her
my
Ambien
life's greatest
make her
love,
pass out and then
accomplishment,
smothering
and
her with a
wish,
pillow.
my 3Ds,
And the fact that
Daddy,
she's talking
Perrin,
about
Mark
pills
Perrin,
ahead of time,
David and Douglas, and then assigned Julie Jensen.
it does kind of make this
And this is a
letter
photocopy of that letter.
seem a little suspicious.
Julie took that letter and she folded it up in an envelope. She put it in the envelope. She put her neighbor, Ted Voigt's name on the envelope. And she delivered the envelope along with a couple of rolls of film to Ted Voigt. And she said, hold on to this for me. And if anything happens to me, give it to the police. Well, then she heard back from Ron Cosman. And Ron Cosman came out to the house and picked up the film. Now remember, Julie, when she had spoken with Ted Voigt, she was concerned about calling the police because she think the police might think she was crazy. And she really was undecided as to whether Mark was either trying to kill her or trying to kill her and make it look like she'd committed suicide, or whether he was just trying to drive her crazy and make her think that he was trying to kill her so that she'd leave and then he could paint her as being crazy to the police and to other authorities. So she was reluctant to talk to Officer Cosman because of that. When Officer Cosman came out, she told him about the letter and she told him about the film, and he asked to have the letter and the film. She didn't want to give him the letter at that point, but she went and got the film. So she went back over to Ted Voigt's house and she got the film. She brought the film and she gave it to Officer Cosman, who had it developed. And then, now, I'm not sure if Ron Cosman remembers this conversation or not, but according to Ted Voigt, Officer Cosman came back to the house after the photos had been developed. And he saw Julie talking with Officer Cosman. And then he saw Julie walking away from Officer Cosman's squad car. And Julie was doing this. As though conveying to Officer Cosman, to Mr. Voigt, that Officer Cosman thought she was nuts for talking about this stuff. Now you're going to see the photograph that was developed. And what Officer Cosman will tell you is that when he had the photo developed, when he had these photos developed, it was just a bunch of writing. It didn't really mean anything to him. And he told Julie, there's really no basis for us to suspect that your husband is trying to kill you. And really, if you're concerned about that, you should go to a women's shelter. You should take your children and leave. You should do something like that. Officer Cosman will also testify that when he came out to pick up this film, Julie was initially very emotional and agitated and upset and was talking about how she believed that her husband may be trying to kill her. But then as she was talking to him, it's as though she talked herself out of that proposition. And if you think about it, it is such an absurd proposition that one's spouse is trying to poison you. It's just so difficult to believe. Isn't it kind of difficult to believe right now? Even as you're sitting here, isn't it kind of difficult to believe that one spouse would seek to poison another spouse? It certainly is an unusual way to end a relationship. Even when murder ends a relationship, it's not by poisoning. One party gets drunk and kills the other. That's the typical way it happens. A knife, a gun, strangulation. It's violent and it's quick and it's sudden. That's the way.
Knowledge of the
if these
original
things
trial.
end that way, that's how they
So he is
typically
helping.
end. So you can
Kenosha
understand
County
how Julie would be able to talk
retry Mark
herself
Jensen.
out of this absurd proposition that her husband was trying to murder her. And unfortunately for Julie, that's what she did. She talked herself out of the proposition that her husband was trying to murder her. That's after she wrote this letter. Because remember, this conversation
It'll be interesting
with
to
Officer
see
Cosman,
in opening
where she
statements
starts
tomorrow.
being very
if
distraught,
Jamboy ends
very
up
upset,
giving
very
the
emotional,
opening.
believing that her husband was trying to kill her. And right
And
before
somebody
his
asked
very
yesterday
eyes,
in
she talked
regards
herself
to
out of that.
how is
That occurred
Jensen
after
able
she'd written
to
this letter.
afford this. He's actually represented by
and then on December 1st, and Mark was at this point making a big show about how concerned he was for Julie, insisting that she go see Dr.
He's considered indigent.
Borman.
There's
Not
no
realizing
cost
that really the real benefit in going to see Dr. Borman was that there'd be some prescribed medication. And then Mark Jensen would have a reason to providing her with something to ingest. She didn't want to drink the wine that he'd been trying to get her to drink. She didn't want to eat the food that he was trying to get her to eat. In fact, she'd gone so far as to go to the local White Hen pantry to buy a chicken sandwich so she could eat something without fear of being poisoned. That's it. Now, again, that was before the conversation with Officer Cosman, where she talked herself out of this. But Mark was having difficulty getting Julie to ingest this poison. And what a great way to get her to ingest some poison. Get her to go to the doctor, get the doctor to prescribe some stuff. And then you can get her to take some juice to help get down the pills, and you can lace the juice with antifreeze. I mean, it really worked out very well for Mark to get Julie to go to the doctor. But Julie didn't see it that way. From her perspective, Mark was taking care of her. So on the morning of December 2nd, 1998, at around 10 o'clock in the morning, Julie calls the next door neighbors and she talks to Mrs. Voigt. And she tells Mrs. Voigt, don't worry, you're not going to see me out and about today. I'm not feeling well, but Mark is taking care of me. Mark is being good to me. And Mrs. Voigt will tell you that when she was speaking to Julie, Julie's voice sounded different and it sounded almost like she was drunk. And that's another thing you're going to hear is that in the initial stage of ethylene glycol poisoning, it appears as though you're intoxicated. You know, you're unsteady, your speech is slurred, because really the effect that ethylene glycol has on you is very similar to the effect that alcohol has on you.
That's interesting too.
And so on
because
the morning
that letter
of December
talks about
2nd,
how she doesn't drink much.
As Julie Jensen
right?
lay dying,
and the initial effects of antifreeze poisoning is sounding like you're drunk.
She was nonetheless more content that she'd been in a very long time.
I don't know. This letter to me is a little
Mark was taking care of her.
A little suspect. You know, and is she the one that was searching? Sorry, there's nothing we can do about these ads. Is she the one that was searching on the internet? There's stuff about this letter that's just, it's a lot of foreshadowing and very convenient verbiage that's in this letter. I don't know. I'm not sure if I'm buying the letter. That's interesting. So we do have the letter posted up on our Facebook page if you guys want to read that.
Now that's the end of the chapter as far as Julie is concerned, because nobody ever really hears from Julie again after that. She lapses in and out of consciousness. By the morning of December 3rd, 1998, she's really not aware of what's going on around her. Remember, she was rasping, barely able to breathe all night long. Her son David was
Yeah, we've been trying to
describing
dig
it
up
to
a bunch of
one of
archive
his
footage
friends, another
on
third
this
grader,
from the original
boy
thing.
named Eric Schur, as this. She was breathing like this. And you're going to hear expert testimony that that's consistent with the third and final stage of ethylene glycol poisoning. Mark had been hearing that all night long on the morning of December 3rd, from past midnight right up to the time when he propped Julie up in bed so that her two small boys, David and Douglas, could come in and hug her and kiss her goodbye and go off to school. Now, David at that point was about 8 years old and he was in third grade. Douglas was 3 or 4 years old. He was in preschool. But even though David was only in third grade, he knew his mom was desperately ill. And the boys wanted their daddy to take mommy to the hospital to get her better.
I think we all know
Mark couldn't do that.
OJ is
So
not
he made
innocent.
a promise to his sons. He promised them, if mommy's not better by the time you get back from school, then we'll take mommy to the hospital. And of course, children aren't taught to question adults. They listen to their parents. Douglas was taken to preschool. David went off to third grade. And Mark stayed there and watched his wife. And she was breathing, watching her breathing like that, semi-comatose. And so what did he do? What any husband would do: gets in his car, drives off, and picks up a check, runs some errands, and comes back. And what happens then? Now, according to some accounts, Mark Jensen finds his wife dead when he comes back with the boys and calls the police. But according to the statement that Mark Jensen made to Aaron Dillard, a fellow inmate in the county jail, what happened was Mark Jensen came back from picking up that check, and to his dismay, Julie's breathing had gotten better. Julie was starting to recover. She was still unconscious. She was still very sick, but she was apparently on the road to recovery. And Mark told Aaron Dillard he panicked because he knew his children were coming home from school shortly, or he was going to be picking them up and bringing them home from school. And if Julie wasn't dead, they were going to be expecting him to take her to the hospital. So time was of the essence. He no longer had the luxury of allowing the poison to do his work. He had to do it himself. And so Mark Jensen told Aaron Dillard he rolled Julie on her side, sat on her, shoved her face into a pillow, and smothered her. Now, we didn't know anything about that at the time that we were investigating this homicide. We didn't know what Mark Jensen was going to say. On the evening of December 3rd, 1998, when law enforcement showed up, here they had an apparently grieving husband. He was crying. His wife was dead. He had no explanation. He said she'd been sick. Doesn't know how she died. Doesn't know how she died. We didn't really even know if we had a homicide or not, because there were really no discernible injuries. There was a strange thing, though. She'd been sick for 3 days. And he didn't take her to the hospital. I mean, we were suspicious about that. She'd been sick for 3 days. She was had great difficulty breathing, and he leaves her. We were suspicious about that. There were some suspicious things here, but really, and then you looked at Julie's face, and she had been laying on her side with her face in a pillow. You roll her over, and her nose or mouth was pushed off to one side, like this. I'd never seen anything like that. The police had never seen anything like that. But if you stop and think about it, what could be more entirely consistent with the description of the murder of Julie Jensen that was provided to Aaron Dillard than that? How could Aaron Dillard have known about the photograph that you're going to see during the course of this trial showing Julie's face and mouth, or nose and mouth, pushed off to one side as though her face was shoved into a pillow? I don't know. So when law enforcement and prosecution started putting this case together a number of years back, we didn't know about Aaron Dillard. We also didn't know about Ed Klug, and you're going to hear about Ed Klug. We were putting together what's known as a very circumstantial case.
So Jamboy's referring to these jailhouse
thinking of it
snitches.
as like a big, complicated jigsaw puzzle. All these
Also
little
an
bitty
allegation during
pieces,
the original trial that
one colored this way,
Jensen
one
tried
colored
to
that way, and you
hire
put them, and
somebody.
they only go together in a certain way. And once you take all these
to,
little pieces
take
that are just
out,
kind of a jumble,
this
and you
Ed
put them
Klug,
all together, then you see this
one of these
picture.
jailhouse
The
snitches.
jigsaw puzzle creates a picture of
The
the guilt
allegation he tried to
of
pay
Mark
$1,000
Jensen, the manner in which he murdered her.
to take him out.
How did that come about? Because I'm going to tell you about that process first, because that's really how I had expected this case was going to be put together. I had expected it was going to be a laborious, time-consuming process, and it was, of assembling this little piece of evidence here and this little piece of evidence there. At the autopsy, we really didn't know what the cause of death was.
That's where that
After
whole
the
thing in
autopsy, we didn't know what
that
the cause of
pretrial
death was. There was
hearing,
no discernible
regarding that
evidence of it. And you're going to
snitch,
hear testimony that normally you don't test for ethylene glycol
selling
when you do a tox
drugs,
screen at an autopsy.
cocaine to Jamboy.
That's a notable fact,
That's why
because that's a fact that was related
trying to get them
by Mark
impeached.
Jensen to Ed Klug in November of 1998. But I didn't know that back then. We didn't know that Mark Jensen had told Ed Klug in November of 1998 that he was planning to murder his wife. We didn't know that. We didn't find out about Ed Klug until just a few months ago. So for the last several years, as we were putting this case together, what we had was evidence that was just kind of coming up a little bit at a time. The autopsy didn't tell us anything about really what caused the death of Julie Jensen, except that we knew it wasn't a gunshot. We knew it wasn't blunt trauma. We didn't know what it was that killed her. Then, a number of months after the autopsy, we got the forensic analysis back of the computer. Now, on the night of December 3rd, 1998, law enforcement seized the computer that was in Mark Jensen's den. And we sent the computer and the hard drive to the state crime lab, where it was analyzed by a forensic computer scientist using something called NCASE software. Now, the NCASE software package is one used by the FBI, and what it does is it'll take a hard drive and it creates a mirror image of it, and then it'll go through that mirror image of the hard drive and recover everything that's on the hard drive. Now, I had always thought, and I don't know how many of you folks know, I forgot how many of you know something about computers. I'm an idiot when it comes to computers. I know next to nothing about them. But I thought when I deleted something, it was deleted, it was gone. It was off somewhere in infinity. Well, it turns out that's not the case. It turns out that when you delete something on a computer, it still stays in the hard drive. It's just in something called unallocated space or something like that. It's still in the hard drive. And what the NCASE software does is it pulls all those bits off the hard drive and recovers them. So it was able to recover all the stuff that was pulled, most of it, not all the stuff, but a lot of the stuff that was on that computer, the internet history, the email communications. And what did we recover several months after Julie Jensen's death? Well, we found an internet history search for poisoning. And when does it start? Well, it starts sometime in mid-October. And one of the other things that we found were all these email communications between Mark Jensen and a woman named at various times, either Kelly Labonte or Kelly Greenman. We talked to you during the voir dire about motive.
So that's the
Well,
mistress that he
when you
had
think
that
of
he ended up
motive,
marrying.
Think of Kelly Labonte, the other woman. During sometime in earlier 1998, Mark Jensen had switched companies. He'd gone from, I think it was Baird, over to Stifel Nicholas. And Kelly Labonte was an administrative assistant to Mark's boss in St. Louis, Missouri. And at some point they got together and they had started having a sexual relationship, a sexual affair, a rather torrid sexual affair. Although at that time, of course, Mark was married to Julie and Kelly was engaged to a guy named Mark Riemann. And in fact, during this relationship, during this sexual relationship between Mark Jensen and Kelly Labonte actually went off and married Mark Greenman, and she became known as Kelly Greenman. And as soon as she got back from her honeymoon, she recommenced her sexual relationship with Mark Jensen. But they were talking about getting together, and there was this email communication from October 16th of 1998. And you know, the judge when he was instructing you about intent, so it doesn't matter how long the intent to commit murder existed, you're going to have a pretty good idea when the intent to commit murder commenced in the mind of Mark Jensen. There's no hidden agenda with this guy. It's right there on the internet. So we start with these conversations, this email from Mark Jensen to Labonte, October 16th, 1998, 9:21 a.m. Hey, want to run off somewhere? IDLY. Now, I don't know how many of you folks use the internet. Apparently, IDLY, well, it means I do love you. That's not apparently, we know that. It means I do love you. So, Mark Jensen's communication to Kelly Labonte, hey, want to run off somewhere? I do love you. Her reply, October 16th, 1998 at 7:23 a.m. And I don't know why the times are different like that, but her reply is, what sparked this bold attempt at messing with me? Sounds wonderful. Where should we go? And he writes about Windstar. They should go to Windstar. And there's back and forth about Windstar as a cruise line. Of course, by this time in October, she's married to Mark Riemann, and he's married to Julie Jensen. So there is some details to be worked out here if they're going to go off together on a cruise. And
I'm over 45. I realize I'm no spring chicken.
All right, once again, we can't do anything about the ads because this is archived footage. If you guys are just jumping in here, we're playing some archived footage from opening statements in the original 2008 Jensen trial. So we're going to play the prosecution's opening, and we will play the defense's opening. Kind of give you guys an idea of what to expect for tomorrow's opening statements. There's around 40 jurors left today. There's another 70 on standby just in case most of those jurors get dismissed. Judge Milisauskas wants 16 jurors, including alternates, for this retrial of Mark Jensen. His conviction was overturned and a retrial granted.
so
Wisconsin
Kelly
Supreme
writes
Court deemed
in her
the
email
Julie
on
Jensen
Friday,
letter
October
from the
16th,
grave
1998
violated
at
Mark
8:33 a.m.
Jensen's
So
constitutional
let's say I have
rights
until the
to
end of the
confront
year to decide
witnesses.
one way or the other. And then in January, you can send in the deposit if I'm still in. Deal? Mark replies, fair enough, but no deadline in deciding. Whatever time it needs to be figured out. And Kelly replies, and do you have it all figured out? And Mark replies, I'm thinking so. Some details to be worked on, but then those are just the details, not the big issue. And Kelly replies, it was the details I was wondering about. And Mark replies, details are just noise in the bigger picture. And Kelly replies, and you plan on dealing with the details how? And Mark replies, one at a time. And she replies, Kelly Jensen, or Kelly Labonte replies, evasive little shit. And then later on, it's from Kelly to Mark. You asked me if I wanted to run off with you somewhere. I'd love to, but there are issues we have to deal with. I'm not sure how I'll deal with my issue, thus the deadlines and agreements for any backing out that might be necessary. Do you know how you'll deal with your issues?
Make sure you guys hit that
And Mark
thumbs
Jensen
up, share the
replies,
stream out.
Are deadlines and agreements necessary? I'm not trying to pin
Comment
anything
where
down,
you
and I got
guys
my
are
ticket
tuning in
punched, had
from.
that conversation, heard the answers. We're just hanging out for lack of one of us making a decision, just need to
We are
decide
gonna
what to
kinda
do and make
talk
an
over this a
announcement.
little bit just due to some
Labonte
copyright
replies,
issues.
okay, deadlines and agreements are necessary because I don't want to let you down. Now, this conversation is going on, this
Voir
email
dire in the
communication
new
on October
trial
16th,
commenced
1998.
again today. Opening
From the
statements are
morning
expected to
hours
start
into the
tomorrow.
afternoon.
So as long as they do,
And
we will be
how is
live
Mark
streaming
planning
this
to
trial.
work out the details? Well, he was on the internet. You're going to hear testimony regarding this from our expert. On the morning of October 16th, 1998, between 12 a.m. and 12:21 a.m., Mark was on the internet, and he was looking up botulism, pressed garlic, and poisoning. Now, what's pressed garlic got to do with this? That doesn't fit in there, does it? Well, it turns out that pressing garlic is a very good, potent way to get botulism. So don't do it. You're not supposed to press garlic. But that was what he was looking at in the morning between 12 a.m. and 12:21 a.m. Then he had these email communications with Kelly Labonte, where he's talking about figuring it out. How does he figure it out? He's just got to figure out the details. Well, of course, Kelly Greenman's detail is her husband, Mark Greenman. Kelly's thinking of a more conventional way to deal with her detail. She's going to divorce him. What's Mark Jensen's way of dealing with his little details? Well, then after the conversation, after the email communications, Mark's back on the internet that night, 9:57 p.m. to 11:04 p.m., looking up drugs, botulism, and nicotine. And what you're going to find is that if you do a word search on Mark Jensen's hard drive, the word that comes up more often than any other word is poisoning. Now, but Mark wasn't restricting himself to poisoning his wife. He was an open-minded sort of murderer and was looking for other ways as well. He considered blowing her up. He considered electrocuting her. He went to the anarchist cookbook. He was considering all of his options.
Ooh, the anarchist cookbook.
And
there's a documentary on that.
See, sometime around mid-October,
the author of
word
the anarchist cookbook
ethylene
was
glycol
a
starts
teenager when he
popping up.
wrote it.
And then on December
sold it
1st and December 2nd, December 3rd, the word ethylene, there are a number of
got
ethylene
rid of the
glycol
rights to that book,
sites that are
and it's had nothing to do
searched
with
by
that
Mark
book for
Jensen,
decades
because
now.
obviously he's wondering, why isn't this woman dead yet? I've been poisoning her. Why won't she die?
Little clarification on the
You might wonder
garlic
yourself. Well, there's a very
creating,
small amount
botulism.
of ethylene glycol that's
For those of
discovered
you
in
that
Julie Jensen's
make
system.
some homemade
Ultimately,
oils,
by the way,
and use
the
garlic.
blood, the
If
stomach
it's
contents,
left
the
at
urine
room temperature,
was sent out
it can
to a
create
lab.
botulism.
And so now we can talk about the science a little bit.
For all you homemade
There were 57
household
micrograms
cooks
per
out there,
deciliter of ethylene glycol in Julie Jensen's blood. That is such a small amount that for one of the labs, it was below their detectable, it was below the reportable limit. It's a very, very, very low amount of ethylene glycol to be found in the blood of a person who's dead from ethylene glycol poisoning. Because most
Gotta
people
look
die
that
from
up,
ethylene
the
glycol
garlic
poisoning
thing,
commit
Ghost.
suicide. They ingest large quantities.
I just Googled it.
And then 8 to 24 hours later, they're dead. They've got a huge amount in their blood. They've got a huge amount in their stomach. They've got a huge amount in their urine. But you see, one thing you're going to hear about ethylene glycol is that it, in and of itself, doesn't kill you. Drinking ethylene glycol, it's not the ethylene glycol that kills you. It's the metabolites of ethylene glycol that actually kill you. So the body has to process it, has to metabolize it.
Unrefrigerated garlic in oil
your body
mixes
become
can
very
foster the growth
acidic. And once your
of
body becomes acidic,
botulinum
it starts producing
bacteria,
oxalic acid
produces
crystals. And it's
poisons
the
that do
oxalic
not
acid
affect the
crystals that
taste
are
or
deposited in your
smell of
kidney
the oil.
tubules that shut down your kidneys, eventually shut down your organs, eventually it kills you. Well, there was a very small amount of ethylene glycol in her blood. there was a small amount, about a teaspoon and a half in her stomach, and there was a significant amount of ethylene glycol metabolite in her urine. But
The book?
her kidney tubules were full of oxalic acid crystals, and you're going to hear from
It's an interesting book.
medical examiners that that's virtually
There's like I said,
diagnosable.
there's
It
a
is diagnosable
documentary on
ethylene
it. I want to
glycol
say it's on
poisoning.
Amazon Prime.
So Julie Jensen was poisoned with ethylene glycol.
The guy who wrote it, I want to say he was like
amount
19
in her
when he wrote
stomach, a very small amount in her blood,
and then ended
and
up
yet her
selling the
kidneys
rights to
were
the
full
book.
of oxalic acid crystals.
But a lot of these,
And
like
you can hear
mass
testimony
shooters,
about the manner in which
had that
ethylene
book.
glycol is metabolized and the rate at which it's metabolized, and the stages that people go through. And the first stage is one of inebriation. The second stage is you're having great difficulty breathing. In the initial stage, you're also thirsty, but you can't keep anything down. You're vomiting. You're intoxicated. You appear to be intoxicated. It's an unpleasant situation. Then the second stage, you have difficulty breathing. There's respiratory difficulties, and then the third stage is oftentimes characterized by unconsciousness and eventual death. Cardiac arrest. You just die. And if you ingest, like say 8, 10, 12 ounces of ethylene glycol, typical person is going to be dead within maybe 8 to 12 hours. But Julie was clearly manifesting signs of ethylene glycol poisoning on the morning of December 2nd. And yet she was still alive in the late morning of December 3rd, 1998. More than 24 hours. And this little bitty 110-pound woman. How could that be? Well, you see, unlike a suicide, when you poison somebody, you got to give them a little bit at a time because you want to do it surreptitiously. You can't give somebody a lot of ethylene glycol all at once because they'll know they're drinking ethylene glycol. So you put a little bit in with their orange juice, or a little bit in with the Gatorade, or a little bit in with that, a little bit in with that, to get them to consume the poison. The amount of ethylene glycol in Julie's system is not consistent with a suicide. It's exclusively consistent with a homicide. Now, we thought when we were putting this case together, we try to anticipate the defense. Well, the defense is going to be that it wasn't Mark that was looking up this stuff on the internet. It was Julie that was looking this stuff up on the internet. So we looked at when the computer was being utilized. The computer was exclusively being utilized when Mark Jensen was home from work. There was never any indication of any internet activity, any use of the computer whatsoever when Mark Jensen was at work. It was only when he was home from work. That's one thing. The other thing is there was nothing on that computer that really pertained to Julie Jensen. Nothing. Julie was an avid gardener, and she was into her children. There was nothing from the schools, nothing about the schools, nothing about the children on the computer. There were no internet communications between Mark Jensen and Julie Jensen. All of the internet communications that were recovered on that computer were between Mark Jensen and his girlfriend.
Come be a part of the world's most magical celebration, only here through March. A once-in-a-lifetime moment filled with once-in-a-lifetime magic and memories you don't want to miss. A celebration 50 years in the
Sorry
making,
about the
and all that's missing
ads, nothing
is
we
you.
can do. I don't know why I can't mute the
Join
volume
us
on
now
this one.
for the Walt Disney World 50th Anniversary Celebration, only through March 31st, 2023.
Come on, nobody cares about Disney.
I'm over 45. I realize I'm no spring chicken.
I know what's right for me. I got a plan to which I'm sticking.
My doc wrote me the script.
I can't mute the volume on
on
this
Friday.
on this
I
ad.
screamed with Cologuard and did it my way.
Cologuard is a one-of-a-kind way to screen for colon cancer that's effective and non-invasive.
Ridiculous.
For people 45 plus at average risk, not high risk. False positive and negative results may occur. Ask your provider for Cologuard.
I did it my way.
So we were putting this together, but we were thinking, well, even so, they'll argue that maybe she was using this computer when Mark was at home because she was trying to set him up or something. So we then found a series of actions on the computer that only Mark Jensen could have been doing, and which culminated in him looking up nicotine or some other way of committing murder, poisoning Julie. Because that would show to the jury. We thought at that time we needed to show to the jury that it couldn't have possibly been Julie. So we found this series of use of the computer. There was, first of all, Mark Jensen going on the computer and looking up some stock trading stuff. And Mark Jensen was a stock trader, a stockbroker at that time. Then he goes to the Stifel Nicholas, his Stifel Nicholas Microsoft Outlook account, and he pulls up the email communications, and he's reading the email communications that occurred that day between him and Kelly, thinking about his girlfriend, even though he's at home that night. Then he goes to the Stifel Nicholas account, and he pulls up the personnel directory, and he looks up the name of John Jacques Joseph. And he goes to John Jacques Joseph, he pulls up the information about John Jacques Joseph. Aha. We didn't know. Who's John Jacques Joseph? Why is he looking up John Jacques Joseph? Then he goes from there to looking up, I think it was nicotine, something like that, some poisoning thing. And it wasn't until a number of years later that we'd recovered an additional cache of paperwork that we discovered some notes that Mark Jensen had made when he was clearly interviewing Kelly. He was talking to Kelly over the phone. It was early on in their relationship, and he was having her describe each of her previous lovers, every one of them. Time, date, location, place. And there's the name, John Jacques Joseph. Now, what's the significance of that? Am I trying to embarrass Kelly? No, I'm not even trying to embarrass Mark. The fact is, the only person who could have been interested in John Jacques Joseph was Mark Jensen. Clearly, Julie would not have had any reason to be looking, had never even heard of John Jacques Joseph. She had no reason to be looking up John Jacques Joseph's name on the computer. The only person who would, so this was kind of from our perspective, an aha, gotcha moment. Only Mark Jensen could have been looking this up, and only Mark Jensen would have gone from stock trading to the looking up communications between him and Kelly to looking up John Jacques Joseph, bingo, to looking up nicotine. That would only be Mark Jensen. So we thought that was pretty good. And
all right,
not
April,
knowing
we'll
what
see
was
you.
to come, putting this case together, thinking that would be a big part of the jigsaw, wouldn't it? Because that shows that only Mark Jensen could have been looking this stuff up on the computer. We were putting together the case with that in mind. And then a Friday before a hearing was to start, actually a Thursday night before hearing was to start, we're talking to Dave Nearing, who is a co-worker of Mark Jensen's. And Dave Nearing will testify. He'll tell you that he saw Mark looking up drug interactions on the computer at work. And after Julie's death, Mark was complaining to Dave Nearing about how we had his computer and we weren't giving his computer back, and how he wanted to get his home computer back. And Dave Nearing commented to Mark, well, gee, it's a good thing they didn't take your office computer. They could have taken your office computer and analyzed it that way. This conversation occurred on a Friday. The following Monday, Mark reports the hard drive burned out on his work computer. Imagine that. Isn't that bad luck? I mean, we would have liked to have got that hard drive, but the hard drive just coincidentally burned out between Friday afternoon, when Dave Nearing was pointing out it'd be a good thing. It's a good thing the state didn't have that hard drive. And gee, I guess that occurred to Mark then too, because that hard drive.
So we'll probably tomorrow, we'll
weekend.
probably hear a lot about this computer stuff.
We were talking
again,
about Nearing. That's
in
what
the
we were talking
retrial.
about. And then he tells us, well, of course, Mark had told Ed Klug back in November that he was going to kill Julie. Well, we had never heard this before. This was something new to us. And Dave Nearing says, well, he'd been hearing this. And so he confirmed with Ed Klug. And sure enough, Ed Klug had told him, yeah, Mark told me in November that he was going to kill his wife. So we got a hold of Ed Klug. And sure enough, here's what Ed Klug is going to tell you. He had just joined Stifel Nicholas just in September. In fact, Kelly and Mark had gone to his office in Wausau to help transfer the files over on the weekend from his previous company over to Stifel Nicholas. He said, of course, Kelly and Mark weren't much help because they were just making goo-goo eyes at each other the whole time and were locked up in his office. Didn't do any work. They were just hanging out with each other. But in early November 5th, 6th, and 7th, 1998, less than a month before Julie's death, there's something called the Blueprint. Now, the Blueprint is something that's sponsored by Stifel Nicholas. They bring all their stockbrokers to St. Louis, and they have training sessions. And stockbrokers, much like lawyers and physicians, they all have to have continuing education credits in order to keep their license as stock traders and stockbrokers. So the company sponsors this whole thing. And like any of those, any of you guys ever want, any of those folks ever been along those things, you know that what happens is this: you go to the training session during the day, then you have dinner, everybody drinks, and then you go after dinner, you go somewhere else, and most everybody drinks. And a lot of people drink too much, some people don't, you know. Ed Klug was at that retreat, the blueprint, with Mark Jensen. And Ed had just come into the company. About the only person he knew there was Mark Jensen. So they had dinner together. They drank before dinner. They drank during dinner. They drank after dinner. And then after dinner, they went to the bar and drank some more. And there were other people present. Kelly was there. Another woman named Dawn Cooper was there. There were some other people there. But the other people started filtering off, you know. But not Ed Klug and Mark. They were kindred spirits. They were staying there. And when they became alone, they started complaining about each other's respective spouses. Ed Klug was complaining about his wife. Mark Jensen was complaining about his wife. Now, Ed Klug will testify that he and his wife had been having some marital difficulties, that in fact, he had moved out and filed for divorce the previous year. And even though they'd reconciled and he'd moved back in, he still had some lingering discontent. And with the sufficient quantity of alcohol and beer and wine, it was coming to the surface. And he was telling this to Mark Jensen. And Mark Jensen had also had copious amounts of alcohol to drink, and he was thinking, aha, I've got a kindred spirit here. So Mark Jensen started telling Ed Klug about what he was going to do with his problem wife. He said, you go on the internet and you find ways to kill your wife on the internet. And there's this drug that you can use that it's not typically looked for at autopsy, and it crystallizes you from the inside out. And he went on to describe how you give her Benadryl. She takes a lot of Benadryl, so you get her on the Benadryl, and then you give her the antifreeze, and it'll kill her. And Ed Klug was transfixed by this conversation. He would go back to his room every once in a while to use the restroom or something, and his wife would call. Now, his wife you can hear it from Joan Klug, and she'll testify that she suffers from fibromyalgia, and she was suffering from fibromyalgia back then, and she doesn't sleep very well. She doesn't sleep through the night. And she knew that her husband was going to be up because he goes these things, he goes out and he drinks. And so she felt comfortable calling him and talking to him. So she called him several times that night. And the first time she called him, he tells her, well, I was down with Mark and we were talking about, and he was talking about killing his wife. She said, what? She's, well, don't go back down there with that crazy guy. Don't go. He said, no, I'm going back down. And she was opposed to him going back down there, but he went down anyway. And he would come back up every once in a while and they'd talk some more. And he was telling her about, giving her basically a blow-by-blow description. And I don't know about your situation, but I know that in my family, my wife's got a much better memory than I do. And in this particular evening, Ed had been drinking and she hadn't been. So Joanne Klug actually has a better recollection of all that was going on than Ed does. And then the following day, on November 7th, Ed called her from the airport, told her he was coming home. And Joanne Klug had some questions. Well, how does the Benadryl kill you? I don't get that. And he says, oh, it's the antifreeze. You take the antifreeze with the Benadryl. That's what he's going to do. I don't know why Ed didn't tell somebody about this, but he didn't. But he did he didn't tell anybody in law enforcement. He told his two secretaries about it. He told his wife about it, obviously. But also, when he got back, he told his secretaries about this conversation he had with Mark. Then, less than a month later, December 4th, December 5th, something like that, he finds out that Julie Jensen had died. So Ed Klug comes out and tells his secretaries, Julie died. And one of the secretaries, I think her name was Stacy Bauer, says, my God, he did it. He killed her. Now, when Stacy Bauer will testify, she probably doesn't remember the initial.
So you're 45. That's the perfect age to see some old friends, explore.
the stating of their opinion. That's improper.
Overruled, which will be discussed later.
I want to make clear, I don't want to, certainly nobody else's opinion besides yours counts. Not my opinion, not Mr. Alvey's opinion, and not Stacey Bauer's opinion. And I didn't offer that, what Stacey Bauer had to say, as confirmation that Mark killed Julie. But you see, when Stacey Bauer testified the last time on this matter, she didn't remember Ed telling her that Mark had been poisoning his wife when he came back from the convention. She didn't remember that.
So if you guys are just tuned in,
she did remember that when he came out and announced
jury selection is
Julia died.
still happening today.
Saying,
they're hoping to see the jury by
so she remembered that
noonish.
portion of the conversation. So that's the reason I'm telling you about it.
Not
it's
sure
because
if Judge
it demonstrates
Milisauskas
that,
will
in fact, Ed Klug did
try
tell
to start
his two
opening
secretaries
statements today, or if he'll wait till
Mark
tomorrow.
was talking about ways to kill his wife. In fact, right after the conversation, the following morning, first thing, Ed had spoken with Ron Ruck, another manager at Stifel Nichols, and said, I don't know if I'm going to take it and make it to the whole thing, because I was up all night talking with Mark Jensen. He was telling me ways to kill his wife. So it's not as though Ed Klug was making a secret out of this whole thing. You can hear the testimony from Ed Klug. And why didn't he come forward? After he'd heard that Julie had died, he talked to his wife about it, and she said, well, whatever you choose to do, I'll stand behind you. So I guess Ed thought in his own mind, he'll wait for somebody to ask him. If somebody asks him, he'll tell him the truth. He certainly has never withheld the truth. But he didn't come forward, not for 8.5 years. We didn't find out about Ed Klug until late July of 2007. And so now you know what Mark Jensen was planning. I can't conceive of any reason that Ed Klug would have to not come up here and tell the truth. He certainly had reason to not come forward sooner, because Mark was his boss. From November through February of 1999, he viewed Mark as his boss. And he was afraid of Mark. And he still is afraid of Mark. And you're going to hear testimony that will give you good reason, that you'll understand why maybe Ed Klug just understands Mark Jensen. Maybe that's why he was afraid of him.
The objection is sustained. Confine your remarks to acquainting the jury with what you expect the evidence to show, and not to arguing why the jury should believe one witness or another.
Thank you, Your Honor. Well, again, I hope I'm not giving you some impression that my opinion on who's telling the truth and whose isn't is something that you should take into consideration. You're the finders of fact in this case, not anybody else. But in determining whether or not Ed Klug had reason to be fearful of Mark Jensen,
I think you need to confine yourself to what you expect the evidence is going to show, and not argue to the juries why they should consider the evidence in one light or another.
Well, what I believe the evidence is going to, thank you, Hunter. What I believe the evidence is going to show is this, that after Mark Jensen, at some point during the course of that last hearing, Mark Jensen was reincarcerated. A new judge had heard the case, had seen the case for the first time, decided to change the bond. Mark Jensen was reincarcerated. And Mark Jensen is complaining to other inmates about Ed Klug. In fact, he's showing Ed Klug a transcript of Ed Klug's testimony to a number of different inmates in the county jail, getting their opinion about what about it. I mean, he showed it to Aaron Dillard, and Aaron Dillard will testify, well, man, it looks to me like you're not
yes,
trouble here.
Trish, he was originally convicted in 2008 and
he got
sentenced
Mark
to life
Jensen
in prison
to admit
with
to
no
him that, in
possibility
fact,
of parole.
He murdered his wife.
This case has been held up in the Supreme Court for
with
years.
With respect to another witness,
and the Supreme
Mark Jensen
Court
was in custody with a fellow by the name of David Thompson.
That
David
the
Thompson
letter from the grave and statements made by
Aaron
Julie,
Dillard, by the way, has a record longer than my arm.
not have
normally,
come
as a
into the
prosecutor,
original
I don't pay
trial
any
because
attention
it
to bank
violated
robbers or
his Sixth Amendment right to confront
Again,
witnesses.
I want you to.
So, due to all of that, he was granted a retrial.
You could briefly refer to your hesitance about using witnesses of this caliber, but I don't want you to argue the case.
Started yesterday. The jury selection.
Gamboy's views aren't relevant, aren't admissible.
Jury
There's
selection
not
is
evidence
gone
that he presented in this case
into
about how he
today.
feels.
Well, I
They're
understand
not
that,
live
and that's why I
streaming it.
cautioned
They're
him
only
just very
allowing
briefly,
still
I think
photography
he
for the
can give
jury
some explanation
selection.
as to
Opening statements for the retrial are expected to start tomorrow.
It'll be ended at
I
that.
I object to any opinions of Mr. Jamboy's being admitted at any time.
Your objection is noted. Go ahead.
Thank you. Well, look, let's forget about me for a minute. You might understand that most prosecutors are not going to pay careful attention to a guy like Aaron Dillard, who's got a record as long as ours. I mean, prosecutors try to lock people like that up.
So what we're watching now is
But
the
in the
original
instance of
2008
David
opening
Thompson.
statements.
In the instance of David Thompson,
Kind of give you guys an
which is
idea
not
of what
something
we can
ordinarily would be
expect
taken
opening
very
statements to
seriously.
sound like tomorrow.
David Thompson comes
minus
forward
the
and says,
mention
yeah,
of
Mark
the letter.
Jensen wanted to, and I were talking about what it would cost to have Ed Klug just taken out of commission, sat on during the course of the trial. And it was $500 up front, $500 later on. That's what David Thompson will testify to. Now,
so Julie Jensen died in 1998.
You know? Well, then it turns
took
out
a decade for this
that when
case
you're
to
locked
even
up in
go
the
to
county
trial.
jail, the only phone you can use is one where you make collect calls out of the jail. And every one of those phone calls is run by the
found
same
guilty.
company. I mean, every one of those, that phone is operated by one company. And every one of those phone calls is recorded and monitored. And every single one of those phone calls
We have another
commences
stream
with a
up
recording.
on the YouTube
You-
channel
and
that
when
we
it's
did
the person who receives
yesterday
the phone call,
that
picks up
kind
the
of
phone
gave
call,
a
picks up the phone and says,
background.
hello, this is so-and-so. You've just you're receiving a phone call.
We kind of gave a background
and then the
about
person's
the
supposed
case.
to say their name, in this case, Mark Jensen, an inmate in the Kenosha County Jail. This phone call is subject to monitoring and recording. And so there are a number of these phone calls. One of the people that Mark Jensen called after this conversation with David Thompson was his mother. And he relates, remember how the boys used to, if Douglas was doing something that David didn't like, David would just take him and sit on him.
Verdict. It's a 2008.
And the mom really didn't know what he was talking
court
about.
stuff
and
that
Mark
happened
was
in
laughing about it, saying, yeah, it's
2013.
kind of a Bachlian kind of a thing. And Bachel is the name
Like I
that
said, since
everyone in the
2008,
family
with the
uses to
appeals
describe Dan
process,
Jensen,
it's gone
Mark
to
Jensen's
several
father. I don't know why they
different
call him
courts
Bachel,
in
but they
front of
call him
different
Bachel.
judges, the higher
Bachlian
courts.
thing was his perspective. And he was talking about how somebody's going to help him. They're going to sit on somebody. And he may need her to do some things. Now, he didn't connect up her doing things with that. He had that conversation about sitting on somebody. And then later on, kind of in a disconnected way, he brings up, well, you may be talking to a Kim Thompson.
The
You take this
Wisconsin
number
Supreme
down,
Court said
call
that
her
he should
up,
get a new
and
trial.
he gives
The state tried to
his
send it
mother,
to the United
Kim
States Supreme
Thompson's
Court. They
telephone number. And
refused to
Kim
hear
Thompson
it,
is David Thompson's wife.
which kept the
So
standing
if you-
that he should have gotten a new trial.
Whatever significance you attach to David Thompson's testimony, completely up to you folks, not anything I would have to say. Take into consideration, it's not just David Thompson.
So the state
It's
had
Mark
a
Jensen
decision to
contacting
make
his
on whether or
mother
not to
after he's spoken to
retry
David
him.
Thompson.
They chose to.
Apparently, seemingly
There was a
doing
new
some things that were
verdict,
necessary in order to
a new
accomplish this
bond
objective of
hearing
having
based
Ed
off of
Klug
that.
taken
And
out of commission and sat
he's
on during the
been
course of the trial.
on a
And Mark Jensen was
$1.2
talking about doing
million
that
bond.
with David Thompson and talking about fulfilling his end of that deal with David Thompson when he was talking with his parents. That's what the evidence is going to show.
He's been incarcerated the entire time.
When you're considering the testimony of Aaron Dillard, again, that's entirely up to you in terms of what kind of credibility to assess to Aaron Dillard. But when you're listening to Aaron Dillard, listen to what he says and consider how could he possibly have known? How could he possibly have known some of the things he's talking about if Mark Jensen hadn't told him, hadn't specifically told him? After you've heard all of the evidence in this case, ladies and gentlemen, you're going to see the jigsaw puzzle of evidence that we put together, and that jigsaw puzzle of little pieces in and of itself shows the guilt of Mark Jensen. And all the testimony of Ed Klug and Aaron Dillard and David Thompson and a variety of other inmates does.
So right after
is it
this, we'll
puts it all
play
in
the
perspective.
defense's
It makes
opening
the
statement
picture
from
even clearer
2008.
still.
Kind of give you guys an
And when
idea
you're done
of
hearing the evidence in this case,
what we might hear from the
you will
defense
see
tomorrow.
that Mark Jensen spent weeks
Again, minus
and months
any reference
obsessing
to
and thinking
Julie
about
Jensen's
how he was
letter.
going to get rid of his wife, and seized upon what turned out to be very nearly the perfect way to murder your wife, but not quite good enough. At least that's up to you whether it's quite good enough. Thank you.
Thank you, Mr. Jambois. Let's take a break of about 10 minutes. Please don't talk about the case during the break.
Judge, during Mr. Jambois' opening arguments, there were some statements regarding the jailhouse witnesses, Mr. Dillard and Mr. Thompson, along the lines of, and I'm paraphrasing if I find my note, but it was basically that ordinarily he would ignore, he being Mr. Jambois, would ignore such evidence. He asked rhetorically, why would we pay any attention to that? And then went on to explain why he was giving attention to it in this case. That's vouching for the witness. It's improper. And that's why I objected. And the objection was overruled, but that was improper vouching. Because he's giving his opinion. He's like, hey, ordinarily this stuff wouldn't convince me, but boy, I'm convinced. That's the effect of that argument.
Is this the one where I cut you off after the word objection? Because I thought I had instructed Mr. Jambois that he wasn't to comment on whether how the jurors ought to view the evidence, and maybe not use the same words you did, but I did tell him to just state what he believed the evidence was going to show and leave it at that.
Yeah, and then
But anyway, your objections noted in the record.
And the other one was to Stacy Bauer, which I think will be, maybe an issue when we get to trial. I understand my objection was overruled, but her statement of, I bet he killed her, is, I think, effectively Hazelton type testimony too.
Well,
or an improper, maybe not exactly Hazelton, but it's an improper statement as to her belief about what happened.
Yeah, and it was not received, and Mr. Jambois actually saved me an instruction on it. It was not received to prove or to offer that witness's opinion, but really to explain that she must have had some prior reason to believe that this woman's husband would kill her.
In which case, I think it's worse, not better, because there's the same prejudice of her giving what her belief is. And then it's also requires her to speculate. She's not stating what she actually heard. She's just speculating about what she heard, and she really doesn't know what her source may have been for believing that. It may have been just something about how she looked at Mr. Jensen or the fact that she saw him with Kelly.
And that's what your cross-examination is for. But I understand your objection, but I'm going to overrule it. Anything else?
No, Judge.
All right. Anything from the state? Okay, let's ask the jury.
So I thought there was nothing wrong with my opening statement, but I understand that people disagree.
All right.
All right. So we just heard the 2008 prosecution opening statement. So that should kind of give you guys an idea of what to expect tomorrow from the prosecution. Jamboy is helping the Kenosha County DAs prosecute this case again because of his knowledge of the case. So he's back on it as a special prosecutor. Yes, the original judge was Judge Bruce Schrader. Schrader's not happy that this has gotten kicked around a bunch. And yeah, he's kind of irritated. Hang on, we're gonna. I did want to pull this up. So before we get into the 2008 defense opening, and pull up the letter again. So we have this posted on our Facebook page. You guys can go and read it there. We also posted the original criminal complaint that's on from the original trial. So that's on our Facebook page as well. So you guys can, go on our Facebook and share this stuff around. But what's interesting about the letter to me, and, again, this is just an opinion. Some interesting things that we heard during that opening statement by the state referring to the letter, because they read the letter to the jury during this original trial. And some interesting things are the internet searches when it comes to antifreeze. So the original death of her was poisoning by antifreeze. They're alleging Ambien, which would have, put her to sleep, and then smothering her with a pillow. Some things that stood out in the letter for me, and if I'm kind of looking at this as a juror, right, and there's obviously a bunch of things we still don't know yet. But I found it interesting where they talked about in this opening statement in 2008, where the effects of antifreeze, if ingested, give this kind of feeling of being drunk. And in her letter, she makes reference to how she really doesn't drink alcohol. So to me, I'm kind of, I don't know, there's a little bit of doubt. I'm kind of questioning, like, why is she bringing up alcohol, right? And then, she makes reference in the letter to medications, how she doesn't take different types of medications. And, again, here we have Ambien that is allegedly used in order to kind of, knock her out, put her to sleep. So there's just these kind of weird things that are written about in a letter that's given sometime before her actual death, where it makes it look like what the defense is, suggesting, that she tried to, she was trying to poison herself to frame Mark Jensen for attempted murder, not thinking that she would end up dead, and that she was doing this stuff to herself in order to frame him, to have him sent to prison, and then be able to get, the kids and all of the assets and all of that stuff. So it's just some weird stuff when it comes to the letter, that certain things are pointed out. So I don't know, something to keep in mind. I don't know, just something that stuck out in my head. Arm says, I found the letter so suspicious, but if they have witnesses saying he detailed his plans to them, that's pretty damning evidence. Yeah, the original thing, so we found some other, other archival clips when it comes to this case, the original case, all of that. And, even Jamboy in some interviews when this was being kicked around to different courts on whether or not he should be granted a new trial and all this, Jamboy has been pretty adamant about the letter was not like the damning piece of evidence that convicted him. There has been some original juror interviews from, right after the case. And then, again, into these years where this case has been kicked around, where even, original jurors have said, the letter wasn't a damning piece of evidence. It sounds like the original jury really focused on the internet searches, him talking about this stuff with other people. So I would assume in the retrial here that, Jamboy is going to focus on the computer stuff pretty heavy, like they did in this original trial. So, but yeah, it is I don't know, that letter, there's just certain things, it just really stuck out that the letter is a little bit suspicious. How are they going to deal with the fact so many witnesses have died or are sick? So what it sounds like from the pretrial hearing that we played yesterday, it sounds like they're going to end up relying on transcript, original video of those witnesses. So, I'll tell you guys, if you go here, I'll kind of share this with you. We'll come back to this letter here in a second, but I'll share this because we're not going to play all of this. But let me just pull this up like this. So this is pretty much the entire 2008 trial. So it has all these witness testimonies. I mean, you guys can go back and pretty much watch the entire trial. All the testimony. They got the jailhouse snitches on here. So this is definitely pretty well documented. We obviously don't have time to sit and watch. I think this was like 6 or 7 weeks worth of trial. But there's a lot of stuff on here you guys can watch. But it sounded, both sides obviously have some disadvantages at this point. That you have people that are dead, you have people that have dementia. So it sounds like they're going to use original transcript from the trial, and then whatever recording that they have. And it sounded like both sides were going to end up having to edit and redact certain things that were said when they're, playing old video or talking about the transcript from the original case. So there's a lot of statements that are made that allegedly are from Julie, and that stuff's not allowed. The letter is not allowed. So it's going to be interesting. A lot of people think that that's not going to matter, that there's still enough evidence to convict him. So, I don't know. It's going to be interesting. We'll find that out. So, but yeah, once again, we do have the letter up on our Facebook page. There's links in the chat. You can get to our Facebook. So you guys can read the letter in its entirety. We read it in our live stream we did yesterday, kind of giving this detailed background on the case. But yeah, there's a few things in the letter that just kind of stood out, seemed a little suspect, seemed a little kind of premeditated by Julie. So I don't know. It kind of rubbed me the wrong way a little bit, but we'll have to listen to the rest of the evidence that they're going to try to use against him. So if you guys are just tuning in, welcome to Never Stop Media. So jury selection for the retrial of Mark Jensen started yesterday. They went into today. There were about 38, I believe it was, jurors that still needed to be questioned in voir dire today. They have another 70 on standby just in case, because they've released a lot of jurors due to knowledge of this case as well as length of time. This trial is expected to last 5 or 6 weeks. So length of time that this is going to last, it's going to inconvenience some people. This is going to be a very hard trial where people don't know about it. This is a big case in Wisconsin. Pretty notable case for us here. And a lot of people honestly in southeast Wisconsin that are kind of pissed off that this case has come back to the courts. The original judge, Bruce Schrader, who you guys recognize as being the Kyle Rittenhouse judge, he is very irritated. Judge Kirkman is another judge that kind of ruled on some decision-making stuff in this case. He's pissed off. I'd safely assume that Judge Milisauskas is not happy this case is back. It's going to be interesting to watch Milisauskas. He's known for snapping on attorneys. He's kind of a crotchety old guy. He's not very nice. He's got a very stern demeanor. So that'll be interesting. So we just watched the prosecution's opening. So now we'll watch the defense's opening. Kind of give you guys an idea of what we can expect from the defense. Jensen does not have the same legal team. He's being represented by Public Defender's Office for the retrial. So we'll see how they do compared to his original attorneys. Yeah, if you guys like the show, share it out. Check out the links that are coming through the comment section. We have the parameters set pretty high in the chat just to keep everything chill and super respectful. I did go back in and modify because we were having some issues. Let me just pause this. We were having some issues with our night bot. Not all the time can our moderators be in here. So we have this night bot that's kind of a computer generated moderator. For those that don't know what that is, posts our links and kind of helps control the chat a little bit. But our Nightbot is a little sassy and has an attitude and doesn't like emojis and caps. And was timing people out. So I did figure out this morning how to get rid of that. So it'll allow you guys to type in caps lock. I don't think it's necessary, but whatever. I don't mind caps. I write in all caps, so I don't really care if you guys do it, but whatever. Emojis, the Nightbot was freaking out about that. So we disabled those features so you guys can put emojis and caps and all of that. But if it obviously starts to get crazy, then we're going to enable it again. But I thought it was unnecessarily limiting people's ability to comment. So that's how that is. We got a couple of articles that are pretty important. So those are going to be, coming through the chat as well. We got one on Judge Doro, who you guys know from the Darrell Brooks trial. Darrell Brooks is the gentleman that drove his red SUV through the Waukesha Christmas parade. So we just released an article on Judge Doro, not the person who you guys thought she was. And then a story that went viral on TikTok. We've been covering this story and we've exposed some corruption in a Waukesha County courthouse. A Wisconsin County courthouse, Fond du Lac County, with a DA who lied to a judge about a sexual intercourse with a child, which resulted in the case getting dismissed. So we actually have 3 articles we kind of posted, which will be coming through the chat. We posted the 3rd article, but on our website, which is also one of the links that comes through the chat. You can read all those articles. If you guys are new to us, we are an investigative independent company. Our investigations take months. We were in Kenosha when the unrest happened in Kenosha. We are the only journalism company that is investigating Kenosha, the only journalism company that has hundreds of body cam videos, video from inside the Bearcat, courthouse camera footage of the unrest. We have several articles on the website what truly happened with the Kenosha stuff. And we'll very soon here be releasing an article on the truth behind what actually happened concerning the Kenosha curfew, and exposing a big lie that the city told not only Kenosha residents, but the entire world that watched live streams of Kenosha riots. So, little introduction there. That's who we are. Let's get to it. Feel free to ask questions. We are going to talk over some of this stuff just due to trying to chill some of this copyright out. Again, check out the links as they're coming through. We are a viewer donation-based company, so there's some links pinned and also coming through the chat. If you guys feel like donating, send some super chats. We'll highlight your comments. And without further ado, 2008 defense team opening statement. Here we go.
Finally, after 9 long years, Mark Jensen can clear his name. Finally, after 9 years, the story will be told about how Mark came to be falsely accused of this crime. Finally, after 9 years, you jurors, 12 ordinary citizens, unspoiled by rumor and hearsay, rather than the government, will decide this case based on the facts and not on speculation, gossip, and guesswork. And those facts will prove that Mark Jensen did not kill his wife. And those facts will prove that Julie Jensen was suffering from depression and despair, and that depression and despair caused her to take her own life. And her depression and her despair and her anger and her delusional thinking caused her to point the finger at Mark. And the police and the medical examiner and the state of Wisconsin followed that lead without a second thought. And today we begin the search for the truth. Let me begin by talking about depression, specifically Julie Jensen's depression. If only it were so simple as suggested that one day Julie woke up and she was now happy because her husband paid attention to her.
Be live streaming that, but I really
People
doubt
who are
Bill
depressed,
Milisauskas is going to want to
you'll
give
hear,
a break and
feel
start
hopeless
fresh tomorrow, but we'll see what happens.
It's irrational. The things that make us feel better no longer make us feel better. It's a dark place. It's terrifying. It's frightening because there's no way out. There is no escape. And how do we know Julie Jensen was depressed? Well, Julie Jensen told us. That's how we know. It's from Julie Jensen. And let me give you, just to give you a little idea of the framework to follow along. Julie Jensen passed away on December 3rd. This is November 1st, and here's the beginning of December down here. She passed away December 3rd. On December 1, 2 days earlier, she went to see Dr. Richard Borman. You'll hear from Richard Borman in this case. And Julie herself made the appointment on November 30th for December 1st. And she went to Dr. Borman, and she drove there by herself. She met with him privately in his office in the confidential patient doctor relationship that we're afforded in this country. And in the privacy of that office, what she told Dr. Borman is, I am depressed. I am miserable. I can't eat. I'm losing weight. I don't sleep. Dr. Borman himself had seen her in September, on September 21st. Julie had gone in for what I think was her yearly physical. And at that time, again, alone, in the privacy of the doctor-patient relationship, she told Dr. Borman she was depressed. But what Dr. Borman saw in December was far cry from what he had seen in September. She was frantic. She was crying. He was fearful for her condition, believing the likelihood of a major depressive disorder. She related that she had marital problems. She related that she did not want to be institutionalized because of how it would look and because of her kids. And Dr. Borman, who had seen Julie for several years and had seen her in September, saw that there was a major change in her condition. And he counseled her, suggested further counseling, and he prescribed Paxil. And Julie also told him about her strong family history of depression. And those are Julie's words, her strong family history of depression. And that was something Dr. Borman inquired about because it's relevant to the concerns you have with somebody who's depressed. It's relevant to things like suicide risk. And Dr. Borman asked, as he typically would when somebody presents, as Julie Jensen did, are you suicidal? Are you homicidal? And Julie denied this. He asked Julie,
we're gonna miss
again,
a press conference
in the
that I was supposed
privacy
to
of
be
this
at.
office. Mark is not there. Mark did not take Julie to the doctor's office. And in the privacy of that office, he asked Julie whether there was any domestic violence.
They changed
And she
the
said
time
no.
to this press
And
conference.
she expressed
that,
no
I was
fears
supposed to go
of her
to.
husband
It's
or any
supposed
of
to be
those
this
kind of
evening, but they
concerns.
changed it
And
to
by the
1.
way, in this case,
I'm not
you
gonna
will
be
not
there.
hear anybody who will ever claim that Mark Jensen was ever physical with his wife.
Here, I'll pause for just a second. So just to give you guys a little update. So it was supposed to be scheduled for like 5 or 6 p.m. tonight, which is why I kind of scheduled to do this live stream now and not do this later on this evening. But they changed this press conference to 1 o'clock. It's happening out here in Milwaukee by me. So there's an individual. Let me just pull up the fucking pressed shit. Sorry, we're interrupting the Jensen thing. So we got some breaking news. I'll end up ripping the press conference from somewhere. So I'm not going to be able to fucking get there. Damn it. So Deshante Adams. So my understanding of this is that let's see. Here's the press release. I'll just read it to you guys. So attorney B. Ivory Lamar. So he handled the Theodore Edgecombe murder trial out here. You guys probably know him. He's a civil rights attorney. He runs around with Ben Crump a lot. So coming right off a Court of Appeals victory in the Joel Acevedo case. So Joel Acevedo is basically our George Floyd. Acevedo, good kid, no criminal background, not a bad person, was actually trying to be a police officer during the pandemic. Milwaukee police officer Michael Mattioli was having a party. If you guys remember, like, we weren't allowed to do those things, but whatever, who gives a fuck? People were bored, so whatever, they're having a party. The alleged version is that, Joel, because he's trying to become a cop, he's hanging around with all these cops, and he gets invited to this party. Mattioli and his goon cop friends basically tell this story that Joel tried to steal something. They tried to stop him. They put him in a chokehold, and it's a very extended chokehold, and they end up fucking killing him. There's a lot of controversy surrounding what actually happened. There's been a victory in the 911 call being released. It's a very difficult 911 call to listen to. You hear Joel in the background begging for his life and saying that he just wants to go home. And then recently, there's now been another great victory that the Milwaukee Police Department body cam footage is allowed to be released to the public. So there's a big court argument over that. We will be getting a copy of that. So once we have it, we'll put it up on the channel for you guys. There will be some redactions to the body cam footage. when it comes to any statements made by Mattioli, because he is currently standing trial for the death of Joel Acevedo. What's really fucked up, though, in this Acevedo thing and with some of these other cases is that the Milwaukee medical examiner, it was widely reported by media that he had retired. We found out from another case that he didn't retire. He was actually fired. And the really fucked up part, not only that lie, is that nobody can find this guy. And he handled some stuff with Joel Acevedo. So now Mattioli's trial is postponed indefinitely because they can't find this guy. And then we just had with another gentleman that we filmed the press conference for there's so many people. Breon Green. So Breon Green is a Milwaukee County in custody death. Green was arrested. And there was he died while in custody in the Milwaukee County Jail. Hung himself with a phone cord inside of a jail cell. There's been some serious controversy over this. We have the press conference up on our YouTube page under the live section. You guys can watch that. So we actually are waiting for the footage from B. Ivory Lamar. They're going to send that to us as well. Once we have that, we'll get that up there for you guys. But again, the medical examiner was part of his fucking case. So this is all held up. And today, the thing that's happening today, the press conference. So obviously we went a little tangent there because this involves a lot of shit. But Joel Acevedo's family is actually going to be at this press conference. I'm a little pissed off I can't go now. Involving open records release now represents the family of Deshante Adams, who was allegedly killed by a self-inflicted wound, according to the Milwaukee Police Department. Lamar is demanding transparency of public records, particularly the Milwaukee Police Department case records and body-worn camera video footage related to the death of Deshante Adams. It was also alleged by MPD that following the shot to his head, Mr. Adams shot another officer. After viewing body cam footage, the Adams family contend that Mr. Adams never raised his hand towards his head, and rather than shoot himself, he was shot by an MPD officer. The Adams family also contend that the body cam footage makes clear that the MPD officer was not shot by Adams. He was accidentally shot by a fellow officer who was moving lawnmowers, which was after Mr. Adams was already deceased. In the video, you could hear an officer yell out, "Put your guns on safety." It has been reported that there have been several accidental discharges with the MPD as of late. That is a factual thing. The firearm that Milwaukee Police Department had as their service firearm, I think it was a Sig Sauer brand of firearm. And there were some fucked up things with this gun, and there was many accidental discharges, which caused Milwaukee Police Department to actually sue. And we covered a press conference on this too, so that's up on the channel. We've posted some stuff about it on the Facebook page. But they sued the manufacturer over this, and they were issued a brand new firearm that MPD is going to be trained throughout 2023 on the new firearm. So there's some interesting stuff about that in regards to accidental firearm that may have gotten this kid, Deshante Adams, killed. So anyway, immediately after viewing the video, the family of Adams requested a copy of the body cam footage. This request was later denied by Milwaukee Police Department, citing an internal investigation and noting that there is a current investigation of a possible criminal offense or possible misconduct connected with employment. The MPD have not offered an explanation as to what potential criminal offenses or possible misconduct is at issue. The Adams family will speak out about the importance of having possession of public records in hopes that law enforcement authorities will adhere to their duty of transparency. Attorney Lamar and Adams family will also be joined by the family of Joel Acevedo, who recently won a Court of Appeals decision after waiting almost 3 years to have the police body cam footage released in the death of their beloved Joel Acevedo. This release will come ahead of the trial involving Michael Mattioli, scheduled for June 5th, 2023. The lawsuit asserts that the internal investigation being conducted in the Adams matter is illegal because it involves the death of Deshante Adams and is therefore contrary to Wisconsin Statute 175.47. Accordingly, Biavri Lamar believes that any investigation should be conducted by an independent agency. We have a law out here that the shooting agency is not allowed to investigate itself, even though these fucking people don't follow that law. Attorney Lamar hopes that the high-profile nature of these two cases will continue to educate government entities, particularly law enforcement authorities, of their duty to make public records immediately and readily available to the public when requested, and not to delay and rely on unfounded exceptions to those who are seeking transparency and justice. So to answer your question, the press conference was originally scheduled for like 5 or 6 p.m. tonight, which I was going to go to. And then we found out last minute that they were changing the press conference to 1 o'clock. But I had already scheduled that I was going to be doing this with you guys. So I'm not going to end this stream and run down the fucking street to go film a press conference that I can just rip for you guys later. We're covering this trial here. This is pretty important. We wanted to get this background stuff out for you guys. But yeah, you guys, now you know what's going on. All right, let's get back to this.
Ever. You will not hear that. In fact, you will hear the neighbors.
So
I'll
end up ripping the press conference from somewhere. We'll put this up on the channel.
Saying that they couldn't really remember an argument. They remembered one time Mark seemed a little mad when he left the house, but there was no yelling or anything like that. Not to say they didn't have arguments, but this was not a volatile situation. Mark Jensen was not a physical man. This was not domestic violence. Julie Jensen also told Dr. Borman that she had been treated for depression before. And indeed, in 1990 and 1991, she had seen a psychotherapist in Kenosha whose name is Paul DeFazio. And she saw Mr. DeFazio then, and as in 1998, I think she began seeing him in the late summer or fall, that is, as in 1998, depression seemed to arise. And some people do suffer from what's called seasonal affective disorder. Short is SAD. And Julie Jensen apparently was one of those people, or at least it was reported by Mr. DeFazio back in 1990. And in 1990, Julie expounded about her strong family history of depression. And she had told Dr. Borman that she was fearful of ending up like her mother. I mean, that was her fear. And she had told that same thing to Mr. DeFazio, that she did not want to end up like her mother. And I think it's even between the time of seeing Mr. DeFazio and Dr. Borman that her mother had passed away. Her mother was an alcoholic. Her mother had drowned in a pool under uncertain circumstances. On what should have been Julie and Mark's happiest day of their life, their wedding, or actually at their wedding rehearsal the day before, Julie's mother, suffering from alcohol withdrawal, had passed out, fallen over backwards, and on the wedding day, visited her in the hospital rather than at the wedding. And Julie was fearful about that. And she had told Dr. DeFazio that she had had earlier counseling when she attended college at UW Parkside. And Julie started out at Parkside, and so that probably would have put it around her freshman year in college when she first had counseling. And then she went to UW Oshkosh to pursue a nursing degree. And she came up, I think, about a semester short. She was a smart woman. She got good grades at Oshkosh, and she knew about the medical field. But back to 1990 and 91, when she was seeing Mr. DeFazio, she reported those fears to him, and the condition was sufficiently of concern to Mr. DeFazio that he referred her to a local psychiatrist, Dr. Nguyen, who prescribed Prozac. And Julie was on Prozac for a period of time. And Mr. DeFazio also had occasion to see Mark. Mark came in to help. That's not unusual for a therapist to want to also see other family members so that they can work out a plan together. And Mark, Mr. DeFazio felt, was overwhelmed by the situation. He frankly wasn't very well equipped to deal with it. Mr. DeFazio didn't know whether Mark Jensen just didn't understand the severity of the problem or just couldn't comprehend it, as sometimes people struggle to do when someone else has depression. He just really wasn't very well equipped. But he showed up. He did what he could. Mr. DeFazio described him as a quiet man who, again, showed up but felt somewhat overwhelmed. And so Julie Jensen then was on Prozac at that time in 1990, 1991. She stopped going in 1991. That was her decision. And it was around that time that she began an affair. It's been referred to as a brief affair. Who knows? I don't know how comforting it is to a spouse that it's brief. It certainly lasted at least 2 nights of passion, if you will, in the Jensen home when Mark was out of town in 1990 or 91, or both. Again, there's no evidence left behind as to how long this affair lasted. And Julie also told Mr. DeFazio about other things in her family. When asked about her childhood, she said bad. She said she had suffered some child abuse. It's unclear whether it's physical or sexual.
This Bucks team is something.
All right, so sorry about the ads. Nothing we can do. This is a archive thing. Oh, gosh, because she's dead, but not his. I don't know, I guess. It's kind of a, I don't know, it's kind of a weird.
And she also had a brother who had attempted suicide at age 17. And again, those things are considered by psychologists, psychiatrists, therapists in assessing, evaluating a patient to determine what their risks are, including what their suicide risks are. And so that's what was going on in Julie Jensen's background. She had counseling at least 3 times, including that Parkside time. And between 1991 and 1998, Julie had her ups and downs. Julie considered her best friend to be Lori Coster, who's Mark's sister. And Lori, who you'll hear from during this trial, as good a friend as she was with Julie,
we're gonna post a copy
like
of
this.
the.
You knew which way the wind was blowing as soon as you.
Sorry, guys. Sorry. So what we were just talking about, we are going to, with this press conference. So we have a copy of the lawsuit. The lawsuit is called the writ of mandamus. Some of you will remember that we filed a writ of mandamus against Kenosha for refusing to give us open records. We won some of that, lost on some other stuff. We still don't have records from them because they suck. But anyway, so we have a copy of this writ of mandamus lawsuit for the Milwaukee records. That's what this press conference is about. So we got sent a copy of that. So we're posting that up on the Facebook page. That'll be up on the page here momentarily. I'll let you guys know when it'll be up.
Met up with Julie for a particular day. She could be very sweet. Other days, you just sort of wanted to back off. And there was one particular incident in the mid-90s that was of great concern. Laura had her son, who was about 3 at the time. Julie was babysitting for him during the day. Lori worked at Abbott Laboratories, and Julie would take care of her son. And he was about a year younger than Mark and Julie's oldest son, David, who was probably about 4 at the time. And then Drake was their second son, who either wasn't born yet or maybe he was 1 and the kids were a year older. But in this episode, Julie called both Lori and Mark frantically from home, saying there was feces all over the wall. And the kids were throwing feces, and there's feces everywhere, and they better get home, and she was hysterical. And Mark rushed home, and Laura rushed home. Kids were sort of standing still, petrified. There was no feces. And the Jensens, or Mark and his sister, Lori took her son home immediately, took a year off until her son started kindergarten. And they just sort of swept that under the rug. They didn't want to talk about it. It was too uncomfortable, and they just sort of pretended it didn't happen.
Is anybody else bored with the defense
what
opening
happens
statement?
when we get to the fall of 1998?
I'm like bored
Mark
with it.
had started a new job as a vice president at Stifel Nicholas. He
was
left Baird. He was
way
doing
better.
very well as a stockbroker. He began that job in, I think, April of 1998, the new
This
job.
guy's better at arguing.
He was very excited.
From the
and it
table
started
than he
out
is
very
at
well.
openings.
He met some people at work that he liked. He was making good money. Seemed like a very good company.
I mean, it's good
he
to
saw
listen
himself
to.
moving up in the world. He was 39 years old. I think it was that summer. He and Julie paid off their mortgage. They had a sizable investment income and holdings. They were doing quite well. And Mark was beginning to socialize with some of the people from work. And the disparity in their satisfaction with life was growing. Julie, in the fall of 1998, was very upset because her youngest son, Douglas, was going off to daycare for the first time. And that meant he'd be going to kindergarten the next year. And Julie would be home alone. And this was a source of great concern to her. When she had seen Mr. DeFazio back in 1990 and 91, she had told him that she was terrified to leave her son David, who's about a year old at the time. She couldn't even fathom the idea of going on a Hawaiian vacation with her husband because she was so fearful of leaving her son. And some of those fears were recurring with the idea of Douglas leaving the home. She also had told Mr. DeFazio that she was the kind of person who keeps things inside, lets things ruminate, she mulls over them. And that could be seen happening again in the fall of 1998. Mark and Julie had good friends, the Brants, who Julie put on a baby shower for at the end of the summer. But when Robin Brant's baby Emma was born later on that fall, Julie couldn't bring herself to go see her. She canceled the family trip. She was struggling to enjoy life's activities, and the person who knew her best, Mark Jensen, saw her becoming increasingly withdrawn. Now again, I said Mark's life was heading in a different direction. And as you've heard, there's certainly no dispute. Mark, toward the end of the summer, beginning of the fall, began seeing a woman from work who worked in the St. Louis office, Kelly Labonte. And they saw each other a few times that fall, and they had a sexual relationship. And Mark was struggling to deal with those feelings and with his wife. Didn't mean he didn't love his wife. It didn't mean he didn't care about the depression. There was some conflict there. And Julie found out about that affair. And she acted as many spouses would in that situation. She began spying. I don't say that pejoratively or negatively. I mean, she began looking a little bit more into his activities. And she'd look at his emails on the internet. She'd look up business associates. She looked up Kelly on the internet, and you'll see that. Is there evidence of poisoning on the computer? You bet. You bet. Is Julie, their background in nursing, her classes in pharmacology, knows what to look for?
See,
and
man,
is looking for those things.
See, there's something, I'm telling you, I
We'll
don't
spend
know.
a lot of time on the
That letter
computers
was-
now.
I don't know.
But-
That letter is suspect. And hearing that she's got a
That's
background
embarrassing.
in some medical stuff, I don't know, man. Here's the thing. So I do have a little bit of like, I don't know if I want to call it like personal knowledge, but the original one of the
November
original
10th.
attorneys on this, Deja Vishny, so she's a very high-profile lawyer.
This was a
She had
page that was
lot of,
recovered from the
civil rights issues
computer.
when it came to Kenosha arrests
Search
and
result.
things like that.
It may be difficult
So,
for you to see. But it's a
Deja
Yahoo
represented
search.
me in my
12
unlawful
categories.
arrest of a journalist in Kenosha.
Yes,
And
I'm sorry, Judge.
she obviously can't give me details on the Jensen case, but she was very excited when Jensen was getting a new trial. The way she kind of spoke, kind of the her disposition,
my other
her
ones will be-
demeanor,
Or even just
it almost sounded to me like she thought, truly thought that Jensen was actually innocent.
And these, I don't expect you to read this, and we've got.
So that kind of
I just
persuades me a little
It's the web
bit.
page.
I obviously want to
And
watch this trial.
we
and
have the
kinda get all
categories
the-
and
all the
sites
facts for myself.
for
but
suicide. There's a search here
I don't know. That letter's super
for
fucking
suicide.
suspect to me.
On the internet. And there are searches for Kelly in the company directory. And these emails are not emails being created at the Jensen home. They're emails that were done at work that are being looked at by Julie Jensen in the home, looking at what Mark was doing at work.
I'm gonna actually reach out to Deja. I'm gonna see if we can get her. See if we to do like a live interview. I don't know if she will. She's kind of a fucking pain in the ass, but to get a hold of and shit. So she travels a lot now. She's retired. She really only comes back for like super high profile stuff. She's not involved in the retrial at all. But I'm going to see if we can get her on. Maybe we can talk to her about the original trial. Maybe she can tell us some stuff, break down some things. So it'll be kind of a long shot, but I'm gonna reach out to her and see. Be kind of cool if we can get her on. Oh, there's Kyle Rittenhouse with his fake fucking tears. That judge they just showed, that's Judge Borowski. So he's handling some of these cases where we're talking about this missing medical examiner. Borowski's a Milwaukee County judge.
Some other things going on in 1998 in the fall. Julie Jensen's and Mark's son, David, he was in the 3rd grade. Julie was a parent helper. She came in on Wednesdays for an hour and a half. And
JK says she won't.
David, their son, their oldest son, 8 at the time, was suffering from tics.
I'm going to try.
For some eye tics. And she had been taking him to a lot of doctors. And it was a great concern to Mark. And Mark was concerned that it may be a reaction to stress created in the home and pressure put on by Julie.
I posted
Mark was concerned because Julie wanted, in his view, to medicate David. And David was a very successful student, and Mark really didn't think anything was wrong with him. And so Mark, there was some friction there.
We'll rip the press conference from somewhere and then we'll put it up on the
went
YouTube
away
channel so you guys can watch it
following
later.
his mother's death. Also in the fall of 1998, as you've heard, Julie one day was sitting on her porch. She knew what time her neighbor, Ted Voigt, would go to work. He worked in Illinois. He'd either leave before rush hour or after rush hour. So she knew if his car was still there around 9 o'clock, she knew when he'd be leaving. And one day he's leaving for work and she's sitting on the porch and she's bawling. She's bawling. And Ted recognizes in hindsight that on this occasion and others that she was waiting for him. She wanted to be seen. And she's crying and Ted says, "What's wrong?" And she begins complaining about her marriage and says things have never been so bad. And then there are more and more frequent conversations and meetings with Ted Voigt outside where Julie is in the home. And this is in November. And she's outside all the time, just kind of waiting for Mr. Voigt. And she begins telling this tale of Mark at various times trying to poison her, that he's leaving things up on the computer screen for her to see, that he's chasing her around with wine. And then on November 21st or thereabouts, she gives him a letter, very cloak and dagger fashion. She puts it in his pocket, very sort of secretively, and says, "Keep this, don't open it." And Mr. Voigt keeps it. She gives Mrs. Voigt some film of some pictures she's taken. She says, "Keep this, I might need it. I might have to get it for the police." And then on November 21, well, over this weekend here of the 20th, 21st, 22nd, sometime over that weekend, Julie called her friend, Officer Cosman from the local police department. And she knew Officer Cosman very well. And she called him because she supposedly was concerned about being poisoned. And she feared, according to at least one of Officer Cosman's police reports, but not others, that she left a message that said, "If I'm found dead, Mark killed me." She did what anyone would who feared not living through the weekend. She left a voicemail for the police. And when Officer Cosman returned from his vacation, as he said he was on vacation, I think he was hunting, he returned on November 24th, and he went to see Julie Jensen. And Julie, again, expressed her fear about Mark's conduct. He had called her first, and even though she had used the phone to leave the voicemail about Mark killing her, she worried that the phone was being recorded, and so she couldn't talk, so he had to come over. And he came over, and she went, and she got the film for him, but not the letter. And he took the photos and developed them and didn't see anything. She said, "Mark is making it look like a suicide." But the notes that she photographed said things like aspirin, razors, there was syringe on it, but she acted like all those things were somehow like a suicide. And understandably, Officer Cosman didn't see it. So that's on November 24th, she expresses those concerns to Officer Cosman. And then beginning on the 25th, she tells Teresa DeFazio, her son's teacher, the third grade teacher, that she fears being poisoned. And Teresa DeFazio offers shelter, just as Mr. Voigt had offered a home of theirs for her. And Officer Cosman had suggested getting shelter. And again, Julie refused all that. By this weekend, she was extremely emotional. She was telling Mr. Voigt, that she wasn't eating at all. Indeed, you'll see weight loss is something that doctors will look for to gauge depression. And from the time that she saw Dr. Borman in September until December 1st, she lost something like 8% of her body weight, I think it is. And then she lost a few more pounds before her death. And she wasn't eating, and she told Mr. Voigt she hadn't been sleeping for days. And that was her condition when she alone went to go see Dr. Borman. And one thing that's certainly interesting in gauging what's going on with Julie Jensen at that time. Can you read this? Okay. These are statements that she was making to these people. She told the Voights, "Mark is controlling. He's demanding that I get a job." But she told Ms. DeFazio, "Mark's so controlling, he won't let me get a job." She told the Voights, Mark's leaving things on the computer for me to see. She told Ms. DeFazio, Mark's covering up the computer so I cannot see. And I guess in theory, someone could say, well, maybe at first he was covering things up and then leaving things on, but it was leaving things on first and then covering it up. She told this to Ms. DeFazio second, and she didn't say anything about him ever having left things on the computer. And one thing before I forget, in early November 1998, when Mark was in St. Louis for that conference, the Blueprint Conference, Julie threw up all over the hallway from the bedroom to the bathroom. And she left it there and covered it with towels, and Mark came back and arranged for carpet cleaners to come and take it. But that was the kind of level of depression. She didn't even bother to have that cleaned up at the time. And there may be some suggestion in this case from someone in the jail that Mark had caused her to get ill on that occasion. The problem, as the facts will show you in this case, is that Julie Jensen never told anybody that she had been sick. She didn't go to see Dr. Borman. She didn't do anything when this whatever happened that caused her to throw up. And there's no indication that she ever missed her appointments or was unable to take her kids' places or any of those kinds of things. And then back to her statements, she told the Voights that she's upset because Mark wanted Douglas in daycare, and she told Ms. DeFazio that she was upset because Mark didn't want Douglas in daycare. She told Mr. Voight, as Mr. Jamboys told you that, no, I'm sorry, that's not this one, but she told the Voights that Officer Cosman, he said he'd install video surveillance. Officer Cosman said, I never made such an offer. She told Ms. DeFazio that this list that she photographed was a list of things to buy. She told Officer Cosman it's not a shopping list or things we would use. In the letter, she said, I don't know what the list means. She told Mr. Voight, this is what Mr. Jamboys mentioned. She told Mr. Voight that Officer Cosman got angry with her and implied that she was crazy. Officer Cosman said that never happened. I never went back to see her after getting those photographs. She told Mr. Voight, we argue about everything.
So they're trying to paint her out as being a liar.
Our relationship has deteriorated to the polite superficial. These contradictions were indications of Julie Jensen's mental state in December 1998 and November 1998.
This is going to be a really interesting case. I'm really interested to see what the opening statements are tomorrow.
Here's the letter.
If they sound similar to what we've heard.
She asserts it was written on November 21st.
Opening statements minus everything relating to
she provided it to her neighbors.
And all of that. What's up, Jess?
And said, keep it in case something happens to me.
And
is that something someone who's fearful of being murdered would do, or something that someone who doesn't want help
would
do?
It's interesting. This letter, man, I don't know. There's something
we'll come back to the letter many times during this case, and you'll have to decide whether it's a blueprint for framing her husband.
There's too much shit.
Or legitimate.
I don't like this letter.
Ion Plus is your home for adventure.
Like I said, there was, we read in the letter. We got it posted up on the Facebook page if you guys want to go read it yourselves. But there was, the talking about the searches on the internet. Now kind of hearing in the defense's opening that she has background to medical stuff, specifically talking about, I don't really drink. But then we find out that antifreeze, if ingested, has a similar effect as drinking alcohol. They said she was poisoned with the antifreeze. He gave her Ambien and then smothered her with a pillow. She made reference in the letter how she doesn't take, different medications. It just seems like there was a lot of premeditated, specific verbiage in there.
The week in which Julie Jensen died,
suggests,
on Monday, November 30th, She had
might have a
karate
legitimate
with the
claim that
kids,
she
and
tried to
Mark's sister was there.
do this to herself to get Mark convicted
And she
of
told Mark's
attempted
sister,
murder.
I won't be here on
and it went
Wednesday. They also had
sideways and she
karate on
ended up
Wednesday. I
dying.
won't be here on Wednesday because I'm going to the doctor tomorrow,
But,
and
you
he's
know,
going to
not
give
to
me
say
some
that-
medication
Let's pretend, for argument's sake, that
I'll have a reaction to, and I won't be
right,
able to
what we
make
just
it.
described.
On Tuesday,
But we also have him where he's
she
like,
goes,
oh, yeah, I didn't
sees
do
Dr.
anything,
Borman.
right? So let's
Late
pretend
that
she
night,
tried to
sometime
set him
after
up for
midnight,
attempted murder.
she begins
I think
acting
there's still some fault, some negligence
intoxicated.
on his
Mark
part,
sees her acting
for sure.
very oddly.
You
Mark
know,
can't
maybe-
figure out
maybe
why
not,
this is the
a
case.
murder charge,
He's
but
speculated as anyone would that it's the new medication
type
she
of
began
reckless
taking that day, the
endangerment.
Paxil. So they both went and they looked up on the internet. They looked up Paxil and possible side effects.
Why can you guys not hear me when I'm screaming over this fucking clown talking?
Feeling right and was still acting unusually. Mark went off to see Dr. Borman. He went to see Dr. Borman and told him that Julie was sick, and he thought it was probably the side effects from the Paxil. He didn't know what Dr. Borman's reaction would be. He didn't know whether Dr. Borman would say, call the ambulance. He didn't know whether Dr. Borman would say, take her to the emergency room. He didn't know whether Dr. Borman would say, I'll stop by on my way home. He came and he told Dr. Borman that there was a problem, and Dr. Borman prescribed some Ambien. That morning, while Mark was going to see Dr. Borman, Julie Jensen called Mrs. Voigt, the neighbor. And she said to Mrs. Voigt, don't worry if you don't see me outside. I'm okay. The medication's affecting me, but Mark's taking care of me. But she called her and said, don't worry if you don't see me outside. Don't know that it would be so unusual to not see a neighbor outside on a particular day, or that it would put up warning signals. But it would be like someone who was worried about their house burning for a long time. And then when the smoke started, they called the neighbor and said, don't worry, we're having a barbecue. You can ignore the smoke. And Julie was sick the rest of the day, December 2nd. And she became sicker on the morning of the 3rd. She was having difficulty breathing. Mark saw that. David saw that. On Wednesday, she also had written a note to Ms. DeFazio saying she wouldn't be in for school that day. And on Thursday, Wednesday and Thursday, she insisted that Mark not get her help. And he did. He shouldn't have followed those instructions, but he did. And when he came home on December 3rd, 1998, at about 4:30 with the kids, Julie had passed away.
All right, here, we'll give you guys a little bit of an update as to what's happening right now with this case. So let me just pull this up for you guys. We're going to kind of interrupt the broadcast here. Let's see. So we already know that jury selection is going into today. They were hoping that it would basically be done by around noon. So to answer some questions that have been asked, we have answered these, but we'll do it again. So they did a new bond hearing once he was granted the new trial. The judge set the bond at set the bond at $1.2 million cash bond. So he's been in custody the entire time. He faces life in prison again with the new trial. We've said before the trial is expected to last 5 weeks. I believe it lasted 7 originally in 2008. So we did a post about the juror stuff today on the Facebook page, but a little update from Lamestream Media. A new pool of over 90 potential jurors were questioned by Milisauskas Tuesday morning on whether they could serve throughout such a lengthy trial. More than half said they could not due to family responsibilities, work commitments, vacation plans, or health issues. Because there were so many prospective jurors, so like we said, there were about 38 that were left over from yesterday. There was another 70 on backup. Because there were so many prospective jurors on Tuesday, initial questioning took place in the court's second floor ceremonial courtroom instead of Milisauskas' much smaller courtroom on the first floor. Milisauskas made statements. The case cannot be tried in a short period of time. That's just the reality of the case. Jury selection process known as voir dire continued Tuesday as attorneys questioned the potential jurors about their familiarity with the case and ability to remain impartial by relying only on evidence presented in court. They were asked whether media coverage in newspapers or television had influenced their opinions of the case. On Monday, over 100 prospective jurors were questioned throughout the day about their ability to serve 5 weeks and also remain impartial. Only a few dozen were chosen to continue on in the selection process. Pool of jurors will likely be whittled down to 16 with 4 alternates. So we posted some of that, which we already knew, on our Facebook page, but there's a few little updates, little behind the scenes tidbits. So sounds like this is still going on. They have not seated a jury yet. It's probably unlikely that they're going to get into opening statements today. It's possible, but I would assume if it's still going on, they're not going to start opening statements at 3:00 in the afternoon. So I think it's safe to say that we'll be able to go live with opening statements for the start of this trial tomorrow morning, and it's expected to go a month. So let's try to get our viewers up. Let's get a lot of people in here. Share these streams out, right? Let's try to get thousands of people coming over to Never Stop, supporting independent media instead of lamestream media. Here we go. Back to boring defense attorney opening statement.
He called 911. I wish we had that tape. It's been destroyed. He called 911. The police came immediately. Officer Riley, one of the first officers on the scene, will tell you that Mark was crying. His nose was running. He was holding the phone, seemingly confused about how to use it. Came because the police knew about Julie's complaints to Mr. Cosman. They began a homicide investigation right away because they were relying on the information given to them. And the next day they got the letter and they talked to the Voights. And December 4th, they also talked to Therese DeFazio, and they began their investigation. And you'll hear, I won't go into the details now, you'll hear about a lot of mistakes
of the kids. I knew they got married
in that investigation. And on December 17th, one of those mistakes was Detective Ratsberg. He's right here in the front row. Detective Ratsberg, who had seized the computer, among other items, was with a state computer expert. And the computer expert told him, what you cannot do to do a forensic analysis of a computer, you can't just turn it on and start looking. As soon as you turn it on and manipulate the information, you'll have tainted the information forever. It changes what's on the computer. It deletes some information. It modifies other information. What we have to do, as Mr. Jamboy's told you, what we have to do is go get a mirror image of this hard drive so we have the original pristine, and then we can use the software that we have to do the examination of the computer. And Mr. Ratsberg said, what do you know? Turned it on, forever tainting that computer. The medical examiner who originally was assigned to this case was Dr. Michael Chambliss. The medical examiner of Kenosha County at the time was a woman named Dr. Maureen Lavin. But for whatever reason, Dr. Chambliss was hired privately to begin doing
big case,
the autopsy in this case. And he did the initial examination and saved tissue samples and things like that. But for some reason, maybe a month or so later, the case was put into Dr. Lavin's hands, and she was the one who handled it. And she's the only medical examiner who has ever written up a cause of death in this case. And Dr. Lavin was not board certified. Generally, medical examiners are board certified in forensic pathology. She was not board certified and never became board certified. And in fact, ultimately, in June 2004, as this case was scheduled for trial, one of the earlier times, Dr. Lavin was fired at the request of Mr. Jamboys because they had a dispute over this very case, and she was fired as the medical examiner. Well, Dr. Lavin did a microscopic examination of the kidneys in this case and saw these oxalate crystals that are a telltale sign, or at least a concern, for ethylene glycol poisoning. And she sent the blood to National Medical Services, and they did the testing, and there wasn't enough in the blood to meet their threshold. They didn't find ethylene glycol. So she sent the blood and the gastric samples, that is the contents of Julie Jensen's stomach, to St. Louis University, which is supervised by Dr. Christopher Long, who did testing in this case. And he tested the blood and found, again, a very minute amount. It would not, if you went into a hospital with that amount, they wouldn't even treat you because it's so little. It's ethylene glycol. One of the ways it acts, and in some fashions it acts like alcohol, and others not. But just like when you drink, it takes a little while for it to absorb in your blood and to feel the effects, and then it slowly becomes eliminated from your blood until suddenly there's not much there. And there's very little in Julie Jensen's blood. And he also tested the gastric contents, the stomach. And he filed a report about how much was in the gastric contents. And he had conversations with Dr. Lavin, and they began putting together this case. And and that was in May of 1999 that Dr. Long tested the gastric contents in the blood. Later that year, he was sent documents by the prosecutor so he could work on the case. And Dr. Long says that he received about 1.5 foot high stack of documents, and he lost them. He lost those documents, and they didn't file a report in 2000 or 2001. And then sometime maybe in 2002, Dr. Long doesn't really remember and doesn't have any notes.
All right, make sure you guys hit that thumbs up, like the stream, share it out, everybody. There's a bunch of links that are coming through the chat. Obviously, be sure to click on those, like and follow the Facebook page, subscribe to the YouTube channel if you haven't already. Check out our website where we write our articles. We do have a couple of articles we're trying to highlight that are coming through the chat, but check out the website, Never.Stop.Voices.com.
2002, he finally filed a report in March, and he consulted with Dr. Lavin and gave her his impressions about what happened. And then in March 19th, 2002, she came back with that final autopsy, and then Mark Jensen was charged on the basis of that autopsy. And what Dr. Lavin and Dr. Long concluded was that the gastric contents, the stomach contents, there was 660 milliliters of liquid in her stomach. Now, I know a number of you weren't very familiar with the metric system. That's about 22 ounces, which probably from soda bottles that are often 1/2 liter these days, you get some sense of that.
Yeah, 23 ounces is a lot of fucking antifreeze, bro.
That her stomach was mostly comprised, the stomach contents were mostly comprised of ethylene glycol. And that led them to conclude this must be a homicide.
Like a liter of fucking.
And the reason they concluded it must be a homicide is this. Because the ethylene glycol, if it had been administered, say, a day earlier, and she had drank 22 ounces, most of it would have left the stomach. She would begin processing it through the body like we all process food. But 22 ounces in the stomach suggested to Dr. Long that it had just, right before she died, she had gotten this big dose of ethylene glycol. But there was crystals, and those crystals had to have come from an administration 24 hours earlier or something like that, at least 12 hours, some earlier ingestion. And that's what would have killed her. So he surmised that someone had to dump it down her throat. And that must be a homicide because there was no bottle of ethylene glycol. There was no way she could have hidden it. And she must have been so sick at that last moment and she went to drinking 22 ounces. And she couldn't hide the bottle, and the police didn't find antifreeze, which he thought was important. And he found it important that there wasn't any antifreeze in the sink traps. Here's part of Dr. Long's report. He says this appears to be a homicide for the following reasons. Ethylene glycol was not present in the house. You'll hear from Detective Ratzberg, he didn't look for ethylene glycol, which you might look for in the garage, but he didn't look for it at any rate. He did not take all the glasses and cups in the house. He did not look, even though there was a suspected poisoning, he did not collect all the items to even search for ethylene glycol or any other toxin. Her stomach contained significant amounts of ethylene glycol, showing it occurred at the time of administration. She would have been too weak to drink the volume.
Oh, I will tell you. So the case, retrying this case is expected to cost the Kenosha County taxpayers $70,000 to retry this case. So that's a little fun fact that we pulled up for you guys.
Of ethylene glycol without help. That again, she couldn't have drank in a bad condition 22 ounces, or maybe he didn't say it was all ethylene glycol, but some substantial, 20 ounces, what have you, a very, very large amount. Multiple doses. All this depends, all of Dr. Long's findings depend on this being a very large dose of ethylene glycol, that the stomach was mostly composed of that. I didn't try to be precise here. This is probably a little bit closer to 600 milliliters of ethylene glycol. But that's what he was talking about.
Put that in a 1 liter bottle, bro, and then show them what that looks like.
Well, the defense hired.
Let me pause this. Look at this. Look at this giant 8th grade science beaker. This dude's got in his hand. I'm sorry, I can't contain myself at this point. Look at this 1980s science beaker that this dude has to put 22 ounces of antifreeze in, right? Sure, it looks like a lot, but it doesn't look near as a lot in this giant 1980s weird science looking ass beaker, right? Put that in a 1 liter water bottle and then show the jury. That's a lot, dude. That's a lot of antifreeze, regardless. I don't know. The original trial, even jurors were saying, a lot of people were saying that the amount of evidence that, is linked to the damning evidence against them, where the letter really didn't make a difference. That's the thing. Let's see. All right, let me ask you guys this question. We're going to play this again. We'll start this. We'll start in a second. But let me ask you, do you want me to pause what we're doing to kind of give you guys a first glimpse at the press conference that I'm not going to unfortunately be at. Do you want to watch that live as it's happening, or would you rather just continue with what we're doing now and then come back to the YouTube channel later on in the day? And we just rip the press conference and you guys watch that shit later. So put a 1 in the comment section if you want to watch the press conference. Like, we'll pause Mark Jensen, watch the press conference live. You guys will get a first look. Or put a 2 if you want to just focus on Mark Jensen and come back to the, watch the fucking press conference later. So put a 1 if you want to watch the press conference now. Put a 2 if you want to come back. So we got 11 people. We should have 11 votes. I think one of those people are me anyway, but we got some lurkers in the background. So all right. So you guys want to watch? Okay. So bear with me. We found one live stream up. So we'll rip that. I'll tell you when some people actually start coming onto this live. Let me get it fucking set up here. I'm gonna keep going with this goofy while I'm getting the other shit set up for you guys. So what's up, April? Ghost says down for whatever. All right, cool. So we'll just keep playing the Jensen stuff for right now until there is a live up, but we'll nobody's standing there right now. So once some people start coming, we'll pause Jensen, switch over to the live so you guys can see that in action, since I'm not going to be there because I chose to do this because they changed the damn time on me. And
experts, a Dr. Denton, who's a medical examiner for Cook County in Chicago, a Dr. Rumack, who's a poison expert.
So
in Denver,
it'll just be a few minutes. They're always late.
They did the calculations.
Especially with B. Ivory.
No, Dr. Long. It wasn't mostly comprised of ethylene glycol. Out of the 660 milliliters, the 22 ounces, half a teaspoon of ethylene glycol was in the stomach. That's the kind of mistake that Dr. Long made in this case. Wasn't caught by Dr. Lavin or anyone else. They pursued this theory. It would have been impossible for her to drink that herself, and therefore it was administered by Mark Jensen. And if those defense experts don't catch this, off we go to trial, the testimony. Somebody's convicted on the basis of that testimony.
No, April, they're still doing the
There's a
jury
later
stuff.
expert, Dr. Mainland. She became the medical examiner after Dr. Maureen Lavin.
Wait. We gotta pause. Okay, we're gonna jump over to this presser that's happening right now. We'll come back to the Jensen thing, guys. We're going to jump over to this presser because you guys wanted to watch that. We were supposed to be there, but it was supposed to, come up later on this evening. And, of course, B. Ivory changed the time. So here we are. We're at this presser. I'm not going to describe what this is. It's on our Facebook page. We went through it earlier. We read what the press release was. We actually have the lawsuit that's attached to this press release. That's up on the Facebook page, so you guys can read all of that. But basically, the short of it is there's some shenanigans happening in Milwaukee once again. They're going to talk about some cases. They're going to talk about this lawsuit for some open records that were denied. We got some suspicious deaths.
All right, good afternoon to the city of Milwaukee, residents of this state, members of the media. I'm attorney B. Ivory Lamar, B apostrophe I, capital I, B-O-R-Y, Lamar, L-A, capital M-A-R-R. I'm the attorney for the Adams family, also the attorney for the Joel Acevedo family, And we're here today to talk about a lingering issue that has been plaguing this state for years, and that is open records. There's been a continuing issue as it relates to families who have experienced tragedies, mostly at the hands of law enforcement. When it comes to getting those records, they're getting denied. I want to just kind of start off by talking about the history of open records laws. I mean, open records in this state started almost 40 years ago. And the purpose of having open records laws is so that the public, so that families, as we see here that's standing beside me right now, can have a guarantee to be able to get those records so that they can understand exactly the circumstances that took place in any incidents that affect this state, and that there's a sense of transparency. Obviously, open records also serve as a check and balance for governmental agencies and specifically law enforcement agencies. When it comes to the families that we have here today, both of which have had circumstances in which those requests have been denied. I want to go back here to the most recent denial, which involves the death of Deshante Adams. This occurred in August 26th of 2022, and it has now been almost 5 months. And this family has still not got any real clear understanding as to what took place. Now, there is something that did happen on August 26th, is that law enforcement, the chief, and other law enforcement members stood before this city and explained that they believe that Deshante Adams died from a self-inflicted gunshot directly to his head. Now, when that information was relayed to the family, they immediately questioned the legitimacy of that explanation. But what can a family do? Only thing you can do at that time is kind of accept what the law enforcement has said, but they know their family member, they know their friend, they know their colleague, and that is something that they did not believe Deshante to have done. It was also alleged back in August that Deshante, after inflicting a self-gunshot wound directly to his head, that subsequent to that, he ultimately fired another shot that ultimately hit an officer, a Milwaukee Police Department officer, in which he was wounded. That was the narrative that was painted back in August. And again, this family, for almost 5 months, has had to live with that narrative. And that is why we're here today. So, if we go back into November, the family will describe before you today the circumstances and how Anisha Adams and the mother of Deshante Adams, Sharon Webb, was able to view the body cam footage that took place on August 26th of last year. And upon that viewing, what they believed the whole time that the story from the Milwaukee Police Department and the accuracy thereof was questionable, was confirmed to them back on that day. Now, I wanted to say at the outset, I personally have not seen the video, but we're here in reliance on what the family has seen and what they partnersly attest to. But in any sake, open records request should be available to anybody. Family members, friends, the community, media, any interested party. That's the purpose of having open records laws. Upon viewing that video, obviously they were completely disturbed. They're going to, and I'm going to leave it to them to kind of describe precisely what they saw. But it's not the same narrative that was told back in August by the police department. And they have reason to believe, as we stand outside of District 5, that it was an officer of District 5's police department that is responsible for some or all of the injuries and the loss of life that occurred on August 26th. Now, you're going to hear the story that after Anisha Adams, who is the petitioner in a lawsuit that we filed today, which was a writ of mandamus, a request from the court to order this police department to release the body cam footage, the incident reports, statements, everything related to what took place on August 26th. That was filed this morning. Media outlets, you now have a copy of that complaint. It has further been alleged that in the response from the Milwaukee Police Department to the open records request that they denied the open records request, but the reason for the denial is very concerning. The reason for the denial is that they stated that it was under an internal investigation. And that caused, I wanted to stop there because that poses an issue right there. Because under Wisconsin Statute 175.47, anytime there is an incident involving the loss of life, when there's a death, the police departments are not supposed to investigate themselves. It should be referred to an outside agency. And what we understand at this point is that has not occurred. So that's the first thing that we're demanding today, is that an outside agency now takes control of the investigation as it relates to the death of Deshaunte Adams. Secondly, it was alleged that it's pending an internal investigation for criminal misconduct of an employee. Now, we've made that available. It's part of our lawsuit. You can see the response from the Milwaukee Police Department that is now available to everyone. And you see in that, the police department said that this is not an allegation. This is not anything that we said. They stated that it was under investigation for criminal misconduct by an employee. Well, we haven't seen any press conferences. This family has not got any phone calls. There's been no explanation whatsoever to talk about what this potential criminal misconduct is. So that's why we're here today. That's why we filed a lawsuit petitioning the court for a writ of mandamus to have these records released immediately. Here we are almost 5 months later, and I hold here, the mother, Sharon Webb, went and got the death certificate of her son yesterday. This was issued yesterday. And what this states is that the cause of death is pending. 5 months later, the death is still pending. So you question why we file a lawsuit to get the open records? Because no death in this state should be pending almost 5 months later. Now, when we go through these actions, obviously, you know, I stand here beside another family, which is the family of Joel Acevedo. And we filed a similar lawsuit back in 2020. We were successful in the trial court. We were also successful, as has been reported, with the Court of Appeals. They agreed with us and have ordered for those records to be released. Now, we're not sure the posture of the respondent in that situation and whether they will want to go up to the Supreme Court. I'm very confident that we will be successful if we do. But again, we're not interested in delay tactics. These families deserve the truth, and they deserve it immediately. You're going to hear from this Acevedo family, who can tell you firsthand what it's like to go almost 3 years without having closure as to what took place in their son's death. You're going to hear firsthand. So that's why we're here. That's the purpose of today. I want to first, we have a lot of different organizations. I'm very pleased with the amount of support that has been garnered in our efforts. So I would like to, just recognize first Anisha Adams, who is the sister of Deshaunte Adams. Let her come forth, and she's going to explain to you what she saw. And then her mother, Sharon Webb, will also come forward. A couple other family members. We'll have a couple community leaders also speak as well. And I'm also going to bring up the Acevedo family as well. So I'm going to ask, obviously, we got a lot of different people that will be participating in this presser today. And I'm going to ask that the comments be limited to just 2 minutes each. All right.
If you guys are just tuning in, we kind of interrupted our Jensen background coverage for a press conference that's happening right now.
Anisha Adams, A-N-N-E-S-H-A, last name Adams, A-D-A-M-S. I am Deshaunte Adams' sister. On November 2nd, my mother and I and my brother, my cousin was my brother, Melvin Campbell, we went down to public records to view the body cam footage. Upon viewing the body cam footage, we were very upset. In the body cam footage, if y'all don't mind, I'll demonstrate. the body cam footage, my brother is standing there behind the house, and I won't say the address, but he's standing behind the house of 3540 North 11th Street in the backyard. His right hand is down to his side and his left hand up like this in the back of the house. As he's standing back there, the officers are like, put your gun down. We just want to talk to you. Put your gun down. He never pointed his arm out to shoot, or you really couldn't even see if there was actually a gun in his hand. But his position was just like this. And there were officers closing in on him on the left, the right, the front, the back. They were everywhere. And it was more than 20. ATF was even there. So he's standing there in the backyard like this, and then they kept saying, put your gun down. He gets down on his knees like this, and he's still in position like this. The next thing you know, he hears movement, which is officers to the right of him. He looks to the right, and as he looks to the right, he stands back up like this. The moment he stands up, boom, he gets shot. He hits the ground. As he hits the ground, officers say, suspect down. The next thing you know, they go, self-inflicted wound. 2 officers are in the yard pulling back 2 lawnmowers, and this is all the audio and everything is on the body cam. 2 officers are pulling back the lawnmowers. As they're pulling back the lawnmowers, a shot goes off, rings off. My brother hadn't even been rolled over yet, and they said when that shot went off, it supposed to have came from my brother. But he never was rolled over yet. So a shot rings off.
This is not us. There's something wrong with
When
their
that
live.
shot rings off, you knew an officer safety. Then you hear another officer say, suspect down, suspect shot, self-inflicted wound, suspect shot, and blood study coming from his head. And I asked him,
Sorry, there's something wrong with their live. I don't know what's going on with it.
why would y'all handcuff somebody who already laying there?
I mean, I obviously we know what's wrong. It's because mainstream media is there and it's fucking in
He didn't
people's live
shoot
streams.
himself, and he didn't shoot no officer, and they should have been better with they cover up, because you couldn't cover that up. He not even right-handed, but he was shot on the right side, and his right eye was blew out. Why? Because he saw them on the right when he looked to the right, and when he stood up, boom, they shot him.
It's perfect.
Oh, this live sucks.
It was August 24th. He turned 43 years. So, 2 days later, changed the clothes. I still got the bag packed up to this day. My son called me and told me he was 4 blocks from me. 20 minutes went past, and I was like, it don't take him 20 minutes to get to me. So I got in my car, because I figured maybe he was tired from walking. And I get to the corner of Keith, and I get ready to turn left, and I see all these police, and I felt this stab in my stomach. And I was like, they're going to kill my son. So I tried to get around. I went around on 11th to Atkinson, and these people was like, police just killed this man. And I was like, what did he have on? I just need to know what he had on. And it was like a beater, some jeans. I said, I need to know about his shoes. If you tell me it's his shoes, I'll know it's my son. But I felt it all the time. And I kept asking the police officer, what went on? What happened? What did the guy have on? They was like, they can't give me no answers. All lies, whatever. So then, There was a camera guy out there. I ain't gonna say from wherever. But he told me to follow him to his car. He told me what the person had on, and I knew it was my son. Then the police want to give me their condolences, talking about, oh, your son shot himself in the head. I said, if I find out that my son didn't kill himself, which I know he didn't, it's gonna be a problem. And now it's a problem because I watched the body cam footage. I saw it. They lied. And I want justice for my son, his kids, my family.
Amen.
I'm not going.
I just want to say something real quick. So when I went in to get the request for the body cam footage, because they were telling me it was going to be available after Thanksgiving, and that I was third on the list and my mom was fourth. When I went in, the lobby was full, and typically they talk to you in the lobby when you step up to the window. Well, it was this one particular officer. He took my ID, took my request slip, looked me up, knew what I was there for. He said, can I talk to you in the hallway? I'm looking like, why I gotta go in the hallway? Why this workstation gotta be private? So I'm like, you know what? Come on, let's go in the hallway. Go in the hallway. He wants to go back and forth with me. Who showed you the body cam footage? I said, don't worry about it. He kept asking, who showed you? Don't worry about it. I said, why does it matter? He said, because it could be interfering with our investigation. I said, what investigation? If y'all claiming he killed himself and y'all chief Jeffrey Norman claiming my brother killed himself and did a whole briefing, then there shouldn't be no impending investigation.
So as you can see here, you know, it causes a lot of frustration with families don't get transparency, and especially just being 5 months, almost 5 months, and still not having any closure and being able to get that type of transparency that this whole city begs. Next, I want to bring up a family who has gone through this same process, gone through this lawsuit. Like I mentioned, one at the trial court, one at the district, at the Court of Appeals back in December, still don't have the video. Still subjected to not having transparency. So what we find here is that open records aren't so open. I want to now bring up the family of Joel Acevedo, both Jose and Maribel Acevedo.
Good afternoon. Reliving for the past 3 years, my son's death has been home. So I feel for the family here because we know what it is to not have transparency. It's been frustrating, but it shows the lack of cooperation, not only with the Milwaukee Police Department, but just in general in Milwaukee with the leadership. I'd like my wife to add a little bit to this.
So, of course, the 3 years of processing Joel Acevedo's case, from the police department chief to the FPC, even from the union, how they dealt with my son's case. The privilege that an officer has being charged to be able to resign under the watch of a police department is sickening to hurting families that are processing a loss of a loved one. All we want is truth.
That's right.
That's it. Truth. Fairness as we deserve.
We all.
There's different cases, different scenarios. There's facts. That's all we want, is for us to be treated as human beings, human life. It deserves some sort of justice. That's all we want is closure. 3 years, going on 3 years. Doesn't feel like 3 years to me. It's like, so my son yesterday I understand everyone has a right to defend themselves. I understand the law that stands. But when the law is compromised, or the law only where does the law stand when they try to, these officers, they're supposed to hold up the law. They break the law.
All the time.
All the time, every day.
This officer was charged and he was able to resign. What kind of laws are those placed? Is that fairness for us?
No.
They hide behind their badge. And they break the law.
Every single day. I want to first bring up Mom Mays
not letting this go. So many people get these answers, and as you've heard, like they can't do anything about it. They don't have, the knowledge or the strength to go and find these answers for themselves. But this family did that, and they did not let it go. And when she first told me about this, I couldn't. It sounded crazy to me. Of all the cases that we have seen, to be able to still be at this point and this not be shifted to an officer-involved shooting. If what we have heard and what they have seen is correct, whether there's an internal investigation or not, there are laws and there are rules. If an officer shot his partner and or their loved one, this should be labeled an officer-involved shooting. And I have said since Dontre Hamilton case, when that law first came into existence, they are not following the state law at all. When an officer shoots somebody, they should not be involved at all at that point. That other entity is supposed to come in and they are supposed to remove themselves. We are seeing officers from the departments who are doing these shootings still being investigated. People, still questioning people, still dealing with evidence, and this is in violation of the state law. How is it that the county is allowing this to happen? How can they have a document and they are not asking these answers? They are allowing 5 months later for it to say pending. We talk about the criminality and we talk about the lawlessness of the city of Milwaukee, but when we have our own leaders and the people who are in charge of the law just as lawless and criminal, then what are we doing here? This is really ridiculous. And again, like to get an inbox about a case like this, to be here to have to continue to say these things after a Joel Acevedo, after a Dontre Hamilton, after all these different cases where we continue to say better this department in this system or we're going to have these problems. This is going to cost us more money. For sure it's going to cost us more money. And I just call on our leadership, the mayor, the county, the coroner's office. I can say enough about the union. They're going to support these officers, whether they're clearly in the wrong or not. That's just a whole thing within itself. But it's so corrupt and criminal. It's mind-boggling. But we don't like coming out here standing in the cold complaining about this all the time? You think people like to be out here and waste their time doing this? When we can just fix it and be done with it? The governor needs to get involved in this stuff. The state legislators need to get involved in this stuff. Because we can't continue to down talk the citizens of this community because they go out and handling things in their own hands because they can't trust the police department and these systems to do it. Stuff like this is the very reason our crime rates are the reason that they are. Because instead of calling the police, instead of going through these processes, you see where it gets you. So why even deal with it? I'm gonna just go deal with it myself. So we can't talk about the people and what they're doing wrong if we're going to allow this to happen. And I hope that Chief Norman, I don't know if he's able to make some comment or something about this.
Needs to say something.
Somebody needs to say something. You cannot let this just happen. Give this family a call. And I know there's legalities you may not be able to make. Whatever it is, do something. They have not had anything.
They don't want to call because they know they're lying.
Again, we're just here in support of both these families. It's still egregious to me how we're 3 years into the Acevedo situation and there's no closure on that. We ain't even gonna get into that. But these body cams need to be, matter of fact, we have my guy here and this organization who have been some of the leading voices in this particular situation when it comes to the release of body cam footage in a timely fashion. And I don't think we've heard anything from that, have we? So the FPC needs to get, this is another instance where you see why that time and energy was spent into saying that they don't need to be the decision makers of when they're going to release this footage to us. There needs to be a mandate. There needs to be a mandate to say you have to release this within this amount of time. And there has to be consequences when they break these laws and when they're in violation of the state law. That's right. And that's all I have to say.
Ivory, you deal with family. You represent families all over the country and deal with law enforcement. How does Milwaukee compare when it comes to open records requests?
I would tell you Milwaukee, as it relates to open records requests, there's other cities and states that have some of these issues, but I would tell you that it's one of the few that can hide behind open records laws and not release records to families 4, 5, 6 months a year. Acevedo's 3 years. They still don't have it. We see, unfortunately, very tragic situations involving law enforcement that have occurred a week ago, 2 weeks ago, and the videos are released the next day, they say. The case in Minnesota where the officer mistaked the taser, and I forget his name, I'm sorry, it's too many. But that video was released like 2 days later, 2 or 3 days later. So Milwaukee is no exception. How does it compromise an investigation by showing people what really happened?
Right.
Now, if there's somebody that robs a convenience store, that video is out on the news the next day. So how come when we have potential criminal conduct as alleged in the denial of this open records request, do we still not see the same video, the factual reliance that they are contending that occurred? It's the same issue. So again, there's a lot of issues here, and we gotta have stronger mandates. I mean, I can't just keep filing lawsuits for open records and going to the Court of Appeals and going to the Supreme Court every single case. There has to have lawmakers that get involved that have mandates, as Vaughn just talked about, and penalties. There has to be an incentive for law enforcement agencies to provide these open records in a timely fashion.
Do we expect the footage from the Acevedo case to come out before the jury trial in June? Do we have a time frame at all?
I will say that we are awaiting. I have talked to the city attorney's office regarding the body footage of the Acevedo case, and what I've been told is that they're just waiting to determine if the respondent in that case, Mattioli, is going to appeal to the Supreme Court. If that's the case, then there's going to be further delay, which likely we won't get it before that time. So
We know the defense says it could impact his ability to have a fair trial.
And that was the argument that was raised in the trial court. That same argument was raised with the Court of Appeals, and the courts completely disagrees. If that's the case, if you don't get a fair trial with having what actually happened, the video of what really took place, so that means that everybody who we see on the news, and when we see, regardless to what the incident was, then that means all of them didn't get a fair trial.
Right.
I mean, if we use the same logic. So clearly, I think that line of thinking is erroneous.
Biagri, where's the line between maintaining the integrity of an investigation and transparency for the public?
I think that, the courts have stepped in and they can determine certain items to be redacted. They do have some precedent that describes the type of information that should not be made public. And what we see in the Acevedo case is that the judge in that case, he decided to blur certain facial components, different identifying information in that case as he deemed necessary. But at least the public has something to rely on to get some context as to what really took place back in April of 2020 as it relates to the Acevedo case. So again, there's things that the courts can do and intervene on, and the police department does have a right. There's several open records requests that I've made with the police department in cases that don't involve law enforcement, and what we see is that they do exercise their ability to redact. So this isn't anything brand new. They know how to make the proper provisions to make sure that it ensures the integrity, but we don't see it when it involves a law enforcement officer. Okay, I want to bring up real quick, John with Milwaukee Alliance.
Name's Omar Flores. That's spelled Omar Flores. I'm with the Milwaukee Alliance. I'm here to stand in full solidarity with the friends and family of Mr. Adams. What happened to them should have never happened to them. This footage being withheld should have never been withheld. And I just want to say, I am very, very tired of standing out here, seeing family after family, saying the same exact thing, that we don't have any closure with the death of our loved one. Could you imagine going for months, sometimes even years, without understanding fully what happened to your loved ones? And the public also has a right to know. And I'm going to tell you why the Milwaukee Police Department is full of it. Because when somebody shot up District 5 right over here, they had that footage out within 2 hours.
Yes.
But when they killed Keyshawn Thomas in there, when he died in there, we still don't know anything about that. And when they did release the footage, it was redacted. So what I'm out here to say is that, it's not just Milwaukee Police Department. They're fully responsible for this, but it's also the Fire and Police Commission, because we've been demanding for 2 years now that all footage of police misconduct gets released within 48 hours. And it's been 2 years that they've dragged their feet on this. How many families have to suffer? How many more people have to suffer while the FBC drags their feet and pretends like this is impossible? But through the Acevedo case, we see that there's no legal precedent for them withholding footage. It's not about investigations. It's not about them trying to uphold the law. It's about them trying to have more time for a cover-up. And the public has no interest in that. We only have interest in full transparency within 48 hours. So I'm also here to demand that the Fire and Police Commission get off their butts and actually get this passed, because it's been 2 years. And it's about time, because I don't want to see any more families suffering, and the public has a right to know. Thank you.
Thank you.
Just to drive home the point about the corruption, Nisha mentioned that in that footage, the ATF was there. That is a federal entity. For them to be there and know that this happened and let them still say that man shot himself, let them still say that he shot that officer, that goes to show the level of corruption. And these are the same people who want to try and prosecute me. And we're supposed to believe them. We're supposed to take their word.
Well,
so let's really think about how serious that is when you have not just the police department there, because we know a lot of these police departments work with each other and they cover each other butts here or there, but you have even the federal entities involved in this stuff and allowing this to happen. So let's not forget that either.
All right. With that, I'll take another question or two, and then at that,
Biagri, why did the NPD allow the family to watch this video to begin with?
so I'll answer that. So at first, there was a detective on the case. They moved him. They're so crooked and corrupt. The detective that was on the case originally, Detective Chad, it was a V. I know how to spell it out over there, but he was originally on the case. They moved him to a different division. So we kept pressing the issue that we wanted to see the body cam footage. We wanted to see a body cam footage. So then there was a sergeant. He called us up and he allowed us to see the body cam footage. When we got there, the lady was playing dumb. So she was acting like she didn't even know who he was. But that detective showed us, and I believe he didn't even know what he was showing us.
They weren't going to give you a copy of it?
No, the detective that showed us, he told us that we can go down to public records and put in a request for it. So we went the next day, and that's when we got the runaround.
Is there anything you'd like to tell us about Deshante, just about the person he is and what he meant to you?
Okay. Deshante Adams, my brother. He was a sweet, loving person, funny. He hung around everywhere. He never bothered nobody. Nobody never bothered him. He didn't have to carry a gun because he had drama. Everybody messed with him, like loved him. He was married. He had 4 beautiful kids. He was dedicated to his kids. You couldn't tell him nothing. He was always interacting with his kids. He loved his family. He was just outgoing. They tried to use his mental health against him as if he killed himself, but he would never harm himself.
Last name Adams, A-D-A-M-S. Deshante is my big brother. I just wanted to say this. You said describe him. So yesterday, while the reporters were at my mom's house, she pulled out something from when he was 9 years old. It was a poem. And I'm pretty sure we all went to elementary school. At the top, it said Sean. At the ending, it said Adams. So you know how you write a poem? And it says, you put your first name at the top, your last name at the bottom.
He was about 12.
It says, I am Sean. I am Sean. Kind, caring, love. That was the truth. I love my entire family. I wish for peace. I hate being talked about. I am afraid of the police and dying. Last name Adams. This is a picture of my brother.
And he did that when he was about 12 years old in school.
So he died with his biggest fears. So what he described himself as a young age, that was him.
All right, any other questions? All right, well, thank you so much. We will keep you updated with any developments in this case. And again, we appreciate the coverage. This is an important issue to the community. And again, thank you.
I need to change the battery.
So that is the press conference. We got to see it. That's good. I'll end up ripping this from somewhere else probably, and then posting that up on the YouTube channel. Let's get back into the Jensen thing. There's definitely, I have a lot to say about that press conference, but let's get back into this.
And I don't know what she and Dr. Long will have to say at this trial, because it appears that their theories have continued to shift. It shifts to so it meets the standard to point the finger at Mark Jensen. As I noted, Mark was charged in March 2002. Many of the witnesses against him were obtained by the state July, August, September of 2007. And some of those witnesses are witnesses who were in the Kenosha County Jail, criminals. You'll hear about them, and you'll have to judge their credibility. And that happened after a new judge changed Mark's bail, although he had never had a bail violation that anyone ever knew about in the 5 years that he was out on bail. I don't know if you'll hear from all of these people. We heard from Mr. Jamboys. You're going to hear from Aaron Dillard. You're going to hear from Big Dave Thompson. Mr. Jamboys put it, Mr. Dillard's record is as long as his arm, and that's in this country. And we'll talk about that. Mr. Dillard, at the time that he was in the Kenosha County Jail, was being revoked on 3 separate felonies. That is, he was on probation or what's called extended supervision that most people think of as parole in 3 separate cases. And on June 21st, 2007, his probation officer had said, I want to revoke you. And what I'm recommending to the court is that you get the maximum on all 3 of those cases. And the maximum based on his original sentence and some other information. On one of the cases, it was over 4 years. On a second case, it was over 2 years. On the other case, it was only maybe 4 months or something like that. But adding those all up was, I think, over 7.5 years. And she said, Mr. Dillard is incorrigible. He's a con man. He's a liar. He ought to get every bit that he can get. Because she had known him for a long time and knew what he was. And as of August 15th, 2007, when Mr. Dillard, or August 14th, 2007, when Mr. Dillard met Mr. Jensen in the Kenosha County Jail, Mr. Dillard was going to get, you can bet, those 7 years that he had coming to him for all of his past behavior. When Aaron Dillard comes to talk to you, he won't be coming in handcuffs. He'll be coming through that door because his time is done. He's not serving any more time. He's already walked out the door. That's the currency in the jail, and every inmate knew it. Mark Jensen, in a high-profile case, he was your ticket out, and Aaron Dillard knew that better than anyone. And so Aaron Dillard, he's still on some sort of supervision, but he got out instead of going to prison for years. And you'll have to consider, what's that worth? What's a year of freedom worth? Is that better than being paid tens of thousands of dollars each year? Mr. Dillard still is facing new charges. He's facing prison on one count, jail on another count, and those cases have been postponed to see if he'll come in this courtroom, and then you can bet Mr. Dillard won't serve the time he has coming to him in those cases either. And Mr. Dillard, you'll hear, has been amazingly successful at conning other people, smart people. And the evidence will show that he's conned some more smart people in this case too.
This is a show with range.
In the know.
Today, we're going to talk about crypto.
In the now.
Wild world of...
All right, so while this commercial is going, so we just had a press conference that we kind of interrupted this to watch. The details of the writ of mandamus lawsuit is up on our Facebook page, so we have the entire filing plus the 2 exhibits that are attached to that filing, so you guys can read that on our Facebook page and kind of see what that's all about.
Came into the Kenosha County Jail on a federal bank robbery charge. His hello, he heard about Mark Jensen on his way to the jail from another inmate, Mr. Bush. You heard all about Mark Jensen. And by the way, Mr. Dillard, he'll tell you, when he came into the Kenosha County Jail, he knew all about Mark Jensen's case. He had been reading about it. He had been studying it. He was prepared. And Mr. Thompson heard from Mr. Bush about Mr. Jensen. And Mr. Thompson's how do you do to Mr. Jensen was that. He hit him. I don't know. I don't know what he goes. I think he's about 280, something like that. He punched Mark Jensen. First time Mark got hit in the jail? Nah. Now, there were others. His commissary, that's the stuff you can buy, soap and candy bars and chips and sandwiches, coffee, routinely stolen by other inmates. He'd been beaten by a man named Jerkowski, and Mark realized he wasn't going to fight back. Telling on those people, you pay a heavy price. And Mark was present in mid-August when a man named Michael Clark was beaten with a sack full of dominoes over and over again by 2 inmates. And when the guard came and Mr. Clark started saying it was Mr. Jerkowski, Mr. Jerkowski went running back in and right in front of the guard began hitting him over the head with a sack of dominoes. That's what life was in the Kenosha County Jail. So Mr. Thompson begins his relationship with Mr. Jensen with a fist and begins demanding that he make phone calls for him, that he give him his commissary. Mark complies. It's easier than being hit. And then Thompson takes a new tact. And early on, almost as soon as he's there, he writes a letter to his common-law wife, I guess you call her. Or you could call her bank robber accomplice, whatever your choice is. But he calls his common-law wife and says, or he writes her a letter, and he says he's going to finally do something for himself, finally do something for Mr. Thompson. And that's try to get credit for Mr. Jensen and try to get credit for somebody else in Milwaukee. And that's what he set out to do. And so he started trying to extort money from Mr. Jensen, and these phone calls, about $500, he was extorting Mr. Jensen. And then after playing the extortion game for a while, and
so
Mark's
the state is alleging
other people were having
$500
money on the books,
and then
they wanted
times two,
$20
so
or $30, or they just wanted his commissary. Now
what
this guy wants
Jensen was trying to
$500,
pay
and maybe another
to
$500
have,
later on.
this
And he
jailhouse
has to,
snitch
he has to talk to his parents,
whacked.
and he doesn't know what to do.
Defense is trying to claim that this was
And then
about
Mr.
extorting
Thompson,
money.
with his master plan of pointing the finger at Mark Jensen, begins talking about, well, I could take that witness. Everybody in the jail knew about Mark's business. They all were reading his discovery. Mark would talk about his case. It was in the news all the time, and they all knew about it. And he said, that witness, that Mr. Klug, I could do something. I could do something with him. We could abduct him and just hold him for the length of the trial. And this was foolishness, and Mark tried to tell his parents without being explicit about this foolishness going on. But then Mr. Thompson's wife was bothering his parents, and Mark realized what had happened. They now had his parents' address and phone number. There was no way out of this. And what he did is he called his lawyer and me, Mr. Jamboys, went to Judge Schrader's chambers, and I said, Mr. Jensen's being extorted. We didn't have any information from anybody about Mr. Thompson going to the authorities at that point. And we went in and we said, Mark's being extorted. We want to make sure that they stay separated. At the time, Mr. Thompson had been moved to a different dorm or pod, they call them. And so he couldn't have personal physical contact with them. But people get moved all the time. And Mark was worried that in the event that they get moved and he hasn't done what Mr. Thompson wanted in those days when they were separated, that the beating is going to be much worse. And that's what Mark had to suffer through. I don't know if we'll hear from these other people. So we'll leave for trial their credibility or lack thereof. Excuse me one moment. The other new witness was Edward Klug. Mr. Klug was in St. Louis at this Blueprint conference with Mark Jensen in early November 1998. Mr. Klug was drinking heavily, by his own admission, over 10 drinks. There were a lot of people there. They stayed up all night until 2 a.m. And Mr. Klug says that at 2 a.m. or thereabouts, it was just him and Mr. Jensen. Well, at least that's what he said last time. I'm not sure what he'll say this time. And that even though in his entire life, before 2 a.m. that night, he had spent maybe 20 minutes talking with Mr. Jensen, he says he had never had a personal conversation with Mr. Jensen in his entire life. And his claim is that Ed Klug brought up what I think he called wife bashing, something that apparently he frequently engages in, bad-mouthing his wife. Things weren't going well for Mr. Klug. He had sort of had an affair. He was worried about divorce. And then he now says that Mr. Jensen was talking about killing his wife. Well, Mr. Klug did not come forward in November 1998. There was some statement about, he told his secretaries, well, one secretary, his assistant of 10 years, when asked if Mr. Klug ever said anything about Mr. Jensen talking to Mr. Klug about killing his wife, said no. She'd remember that if she had heard that. And the other person, when she gave a statement to Detective Ratzberg, she said, I have no knowledge of a conversation Mark had with Ed Klug in St. Louis regarding killing his wife. They didn't back him up. And his longtime assistant, his 10-year assistant, she's been asked, and I expect her to say this in court again, do you have an opinion as to Mr. Klug's character for honesty? She said she did. And it was bad. Her opinion of his honesty was bad. She's asked if she knew his reputation in the office for honesty. His 10-year assistant. Not good. She also characterized Mr. Klug as an attention getter. And so Julie Jensen then passes away in early December 1998. Mr. Klug hears about it immediately, as does everybody in the Stiefel-Nicholas world. He doesn't go to the police. He doesn't do anything. He doesn't do it for 1999. He doesn't talk to anybody. He doesn't do it in 2000. He doesn't do it in 2001. In 2002, when Mr. Jensen was charged, he said he called the police, but they didn't take a report. He says he called the DA and left a message, but they didn't have any record of it. And he says that all he said at that time was, I knew Mr. Jensen. We worked together. He doesn't say anything. He makes calls to the police in 2002, and he doesn't say anything about killing his wife, which I would guess would be the main piece of importance. He just says, I knew him. He doesn't talk to anybody in 2003, 04, 05, 06, 07 until July 27th when he gets a call from the DA's office. And I can imagine Ed Klug talking, I know Mr. Jensen, and this story getting a little bigger as time goes by because Mark's a little bit of a celebrity, notorious figure in the Stiefel world, and Ed keeps talking. And now the DA calls him, and Ed's cornered. And it's either lose face or come and tell his tale. And you are going to have to decide Mr. Klug's credibility. You're going to have to decide whether his word is the kind of word that you would rely upon in deciding the most important affairs of life. Where do I get that language?
Free Movie Channel.
All right, if you guys are just tuning in, be sure to like the stream, share it out. We're playing some old opening statement footage from the original trial. Give you guys kind of a first look at what we might see in opening statements tomorrow. Once this is done, we'll go through some differences from 2008 version of the trial to this new retrial. Kind of go through that a little bit. Give you some updates on the jury information. Comment in the comment section where you guys are watching from.
It means reasonable doubt, that is. Reasonable doubt means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. And I submit that you'll find with Ed Klug that you would not accept his word in the most important affairs of your own lives. One more portion of that instruction I did want to highlight. In considering reasonable doubt, you can consider evidence or lack of evidence. And you'll see on many points there's a lack of evidence from the state establishing its case beyond a reasonable doubt. You will hear from Dr. Denton, who I told you about, medical examiner, Cook County. He's now with Peoria, Illinois, and Bloomington, Illinois. He handles both counties. He'll tell you that this is not a homicide, at least when he looks at the medical evidence in this case. When he analyzes all the medical evidence in this case, he does not find this to be a homicide. He says it's much more likely a suicide. You'll also hear from Dr. Herzl Spiro, a psychiatrist, forensic psychiatrist, who's been doing clinical examinations for over 40 years, who's a professor at the Medical College of Wisconsin. And he did extensive interviews in this case of people who knew Julie. And he read all the reports, and he talked to Dr. Borman, and he looked at Mr. DeFazio's report, and he did a profile of Julie Jensen and her depression. And he found that she was suffering from major depressive disorder. And he found that she was quite likely suicidal. She meets the criteria for major depressive disorder, and she also showed signs that could be suicidal. And you'll hear Dr. Spiro discuss the evidence he examined and how depression works and how it is that he would have been concerned for committing a suicide based on all that evidence and her family history and everything else in this case.
All right, we'll kind of pause this. We'll give you guys some updates. This guy's obviously pretty dry. It's kind of boring. Give you some updates here. So obviously, 15-ish years ago, nearly 15 years ago, the first trial happened. Mark Jensen was convicted for murdering his wife, Julie Jensen. He was sentenced to life in prison without the possibility of parole. This case is bounced with different judges, different courts, higher courts, regarding Julie Jensen's statements and the what is being referred to as a letter from the grave. We have that letter posted up on our Facebook page if you want to read it. We've shown it multiple times. We've read it before in other streams. So voir dire in the case is still going on. They're not live streaming that. They're only allowing still photography. Opening statements are expected tomorrow to start. So here we are with a retrial. Mark Jensen is now 63 years old. The allegation is that he used antifreeze to poison his wife, Julie Jensen, and then suffocate her. She was a stay-at-home mother of 2 children. And the alleged motive is that he killed his wife, Julie, so that he could be with his mistress, who he later married. The defense claims that Julie was depressed and took her own life by ingesting antifreeze, then framing her husband out of spite. So the allegation there is that she wanted to leave Mark, but knew because of some mental health issues that she may not get custody of the kids. She was probably only going to receive half of the marital assets. So her plan was to do these things to herself so that Mark would be arrested for attempted murder. Defense claims that things kind of went sideways in her plan, and she ended up accidentally unaliving herself, and that Mark had no part in her demise. So now we're gonna, basically have a new jury that's going to be faced with the same questions, right? Did Jensen, kill his wife, Julie Jensen? But there's some differences in this particular trial compared to the 2008 trial. So a key piece of the state's evidence in the 2008 trial included the what's being referred to again as the letter from the grave. This is a letter that Jensen's wife wrote before her death that basically said if anything should ever happen to her, that her husband would be the first suspect. So again, we do have that letter on our Facebook page. You can go there and read that. That same letter is what the Wisconsin Supreme Court ruled was a violation of Mark Jensen's Sixth Amendment right to face witnesses and be able to rebut evidence because Julie Jensen is no longer here. The presiding judge in the original 2008 case was Judge Bruce Schrader. You guys will recognize Schrader as the presiding judge over the Kyle Rittenhouse trial. Jensen now does not have the same representatives that he had during the 2008 trial. He is being represented by public defenders Bridget Krause, Jeremy Perry, and Mackenzie Renner. So the only 2 people from the original 2008 trial is Jensen himself, and then Robert Jamboy, who was the lead prosecutor in that case. He has returned to help Kenosha County DA's office out because of his knowledge with the case. Jamboy is now a Portage County Assistant District Attorney. So you guys had some questions in regards to like witnesses and things like that, because both sides, it appears, have witnesses that are either deceased or have some type of illness like dementia. So witnesses that will not be part of this particular trial, this retrial, is Ted Voigt. So we've heard that name multiple times. And I'm probably going to mispronounce this, but Malgorzata Voigt and Officer Ronald Kosman. So these were some pretty key players from the original 2008 trial. Those people will not be available for this trial. What we're watching now, with these original opening statements, this is archived footage that Court TV has on their website. So you guys can go on there. You can watch the entire trial. All the witnesses are up there, all of that stuff. So what it sounds like is the court for the retrial is going to be using archived footage from Court TV to be able to get Ted Voigt and Mal Gorzado Voigt and Officer Ronald Kosman's testimony for the retrial. So it sounds like they're going to be using Court TV's archived footage for that. There was some pretrial motions and whatnot. There is going to be some redactions and edits to those archived footages because there's certain things that are not allowed in the retrial. Another big thing. So this is going to be huge for this trial. So in 2008, the defense was granted a change of venue motion, which allowed the trial to be moved from Kenosha County to Walworth County. A change of venue is typical in a typical request for very high profile cases. They're not always granted, but it is a typical request that helps ensure a more fair jury pool. Jensen's public defenders in the retrial have not made a change of venue request. So his retrial is actually going to be held in Kenosha County. That's where they're doing jury voir dire now. And, that could play a big part in this trial because there was a lot of publicity in the first trial. It was super extensive. The entirety of Kenosha, is aware of who Mark Jensen is. A lot of residents were friends with the Jensens. So that's going to be a big change as well. The jurors, so from yesterday, the first 80 jurors that were pulled on Monday, there were only a handful of them that were asked to return this morning for questioning. The rest were excused. And that's because of the length of the trial or because they had some pretty extensive public knowledge of the original case. 70 more people were summoned for today, day 2 of jury voir dire. His first official interrogation, so, Julie died, I think it was December of 1998. Mark Jensen sat down for his first official interrogation, April of 1999. So on that Court TV archived footage website, you can actually, it's one of the detectives. It's a part 2 of one of the detectives' testimony. You're actually going to see, a pretty good section of that interrogation. That's up there. We're not going to play that. That same year, Jensen ended up marrying the woman, Kelly Labonte, that he was having the affair with. Kelly was a key witness for the prosecution in the 2008 trial, and she has since divorced Mark, but she will return to testify for the state in the retrial. So some updates for you guys there. WTD says, what's this trial about? Sum it up very quick. Mark Jensen was accused of killing his wife with antifreeze, poisoning her. She died in 1998. The case took forever to get to court, went to trial in 2008. With laws changing and things like that, this case got bounced around different courts, went to Wisconsin Supreme Court. There was a letter from the grave that the wife had written. Basically, if anything happens to me, my husband did it. Wisconsin Supreme Court ruled that Mark Jensen should get a retrial because it violated his Sixth Amendment right to face witnesses and evidence. And the state tried to fight that and take it to the United States Supreme Court. They declined to hear the case, ultimately granting Jensen a retrial. So, this case is almost 15 years old now. And voir dire started yesterday, second day of voir dire today. They're only allowing still photography for the voir dire, and opening statements are expected to start tomorrow. So this particular live stream, we're playing the original opening statement from the prosecution, which we did earlier in the first half. And now we're trying to finish the defense's opening statement, which is a little bit more dry, a little bit more boring compared to the prosecution's. Plus, we had a 45-minute interruption because we streamed a press conference that I was supposed to be at, but they had changed the time. Yes, he's getting a retrial due to the right to confrontation. Exactly. So we do have another stream up that we did yesterday, basically giving a lot of background on the Facebook page. We have the letter, a copy of the letter, so we posted that up. You guys can read that. And we posted the original criminal complaint. And we went through all of that in yesterday's live stream. But if you don't want to watch the live stream, you just want to cut to the chase, those things are on the Facebook page. So just a little bit longer of the defense opening statement from 2008. So we're just kind of playing this to give you guys just kind of an idea of what to expect, what we might hear in opening statements tomorrow that are expected to start, and try to give you guys as much info about this case as possible. And this is going to be a very, very interesting case. It's a big one. I live in Wisconsin. I'm from Milwaukee. So this is a big one for us that live out here. We'll see how this plays out. This trial is expected to last 5 to 6 weeks. So we will be here covering, live streaming this trial, provided we get a bunch of viewers and all that. Otherwise, I've taken time off work for this, so it's got to be beneficial for Kevin to keep live streaming this trial. Here we go.
Certainly one big question in this case is that Julie Jensen.
No, they really wanted it. It had something to do with how the law was written back in the day.
Poisoned.
Because I guess sometime
she feared
years
her
later,
husband was going to kill her. She didn't think she'd live through this weekend. She can't eat any food in the house. She's so fearful of being poisoned. And then on Tuesday and Wednesday, on December 1st and 2nd, she gets sick. And if you were in that fearful state of mind to begin with, if you were in that fearful state of mind, you say, oh my God, it's happening. What I've been fearing for weeks is happening. I am sick. Something's gotten into my food. Something's gotten into my drink. Somehow, some way, I am poisoned. I have to do something about it. And I suppose in some case, there may be some situation where some poor person would be poisoned and couldn't do anything about it, had no options, alternatives. Julie Jensen did not want or need any help. She poisoned herself, and therefore she did not want or need any help, and she turned it down at every turn. Mr. Voigt, her confidant, she gives him a letter. She insists that he not open it. She tells him not to tell Mark. There's a point at which on Sunday, the Sunday before she dies, Mr. Voigt sees the Jensens on a family walk. They're on a family walk with the dog. They look happy. Mark looks happy. And then I think Mark goes and he's playing basketball with the kids or something. And Julie comes up the driveway crying because she's depressed. She talks to the Voights, and she has them thinking so they don't tell Mark. Don't tell Mark. Don't let him see you. Don't tell Mark. Well, why not confront Mark? Mark's not a violent man. You'll never hear anything that Mark was ever violent or intimidating. There was some statement on opening about him being powerful, and that's something that Julie Jensen told Teresa DeFazio. My husband's a very powerful man. I can't do anything. Well, Julie Jensen was friends with many people on the Pleasant Prairie Police Department. Mark Jensen didn't have powerful friends. He wasn't a powerful person. And Julie Jensen was not a shrinking violet. When she, in 1990 and 91, she had an affair. Not only did she have an affair, she was going to leave Mark. She filed divorce papers. This isn't a woman who can't act on her own. She has, and we'll get to some more of that, but she is not a shrinking violet. She's smart, she can take care of herself, and she's done it before. And Mr. Voigt says, I'll give you money. I'll let you stay at our, I think it's a lake home that he had. No, no, and no. Mrs. Voigt, that's who she calls on Wednesday. Says, don't worry about me. She's trying to discourage her from making any inquiries that might cause her to get help and put an end to her suicide attempt. Officer Cosman, she leaves a voicemail. Who thinks they're going to be murdered over the weekend and leaves a voicemail? If I want to continue the fire analogy, it's like my house is on fire. I'm going to call my friend, the fireman. If he's not there, I'll leave a message. I won't ask for any of the other firemen. She tells the officer, Cosman, in the voicemail, Mark's trying to kill me. She asks him to do nothing. He says, you can go to the shelter. He'll help her. She doesn't want that. Insists Mark not be confronted. And Officer Cosman's at the house and she's complaining about computer activity. She doesn't show Officer Cosman the computer. She doesn't show him some syringes she supposedly found. She doesn't go and do any of those things that might cause the police to do something and have the whole story told. She can't be exposed. And Laura Coster, her best friend, Mark's sister. Julie Jensen does not go to her home. Laura lives in the community. Her best friend lives in the community. She doesn't go there.
Yes.
Laura is at her
WTD,
house when Julie is making some similar claims.
Let me pause this. She has kind of an extensive mental health history. Some things we pointed out with the letter, which kind of made the letter seem a little bit suspect. You know, the effects of drinking antifreeze give like a intoxicated, like you're drunk type of effect. And she made it a point to put in the letter that she doesn't really drink alcohol. There's an allegation that Mark not only used the antifreeze, but then gave her Ambien to make her pass out before he smothered her. In the letter, she makes a point to write that she doesn't really take medications. So there were a couple of things that were in there that kind of almost seemed like premeditated on her part. And then we learned from watching this old archival footage from the defense's opening statement here that Julie Jensen actually has a medical background. So she would have had knowledge of these different things. So that was something I didn't know. It makes the letter seem a little bit more suspect. However, from the original 2008 case, jurors that ended up giving interviews and other people that spoke out said that the letter was not the damning piece of evidence that convicted him. There's a lot of search history on the computer that the state is alleging that Mark Jensen did, but defense is alleging that that Julie is the one that was on the computer. So some interesting stuff there. Could be some reason to believe that Julie may have been on the computer. So the defense is claiming basically the original plan, because of Julie's mental health issues, that she would not have gotten custody of the two children had she filed for divorce. And she intentionally poisoned herself in order to frame Mark Jensen for attempted murder, and that her plan went sideways and she accidentally ended up unaliving herself, ultimately then Mark getting blamed. So kind of an interesting theory.
As she made to the Voights and DeFazio, Laura is an IT person. She works with computers at Abbott. She doesn't say, let's go to the computer in the event that Julie didn't feel competent for some reason, which isn't the case. Julie Jensen is a very smart person and could use a computer and had for some time. She doesn't ask Laura for any help. She just lets her go. And then she tells Laura, as I said, on Monday, she says, you won't see me here on Wednesday. Just another way saying, I know you might be concerned, don't worry about me. I think she even has a phone call with Laura. The phone record suggests that on Wednesday and doesn't tell her anything. Dr. Borman, a medical doctor who asks about domestic violence, who's there to help. She's been seeing him for years. Denies the domestic violence. She expresses no fear of Mark. She asks for help. Can I have antidepressants? I'm miserable. I'm depressed. I'm crying. That's the help she asked for Dr. Borman. But Dr. Borman could have helped her. Dr. Borman will tell you he sees lots of people for psychological issues. And he also refers women who need help. He refers them for help. Ms. DeFazio, the teacher, she tells her not to tell anyone. Don't tell anyone. Why would you want this to be a secret? She's telling everybody, don't tell anybody. She sends a note on Wednesday morning. She gives a note to David, says, give this to Ms. DeFazio. Ms. DeFazio reads it and it says she's not feeling well. She could send the note, say, I need help. Ms. DeFazio offered shelter and assistance. The letter, what protection does a letter provide? Open it after my death? I mean, that stuff's out of the movie. It's something contrived that somebody would concoct. I can understand if it's your last breath and you scratch out a note, sure. But get help. She writes a letter that won't help her. It will just point the finger at Mark, and you'll see that it's a roadmap to point the finger at Mark. She doesn't give it to the police. Why give that letter to the neighbor and not the police? She insists that they don't open it. Some other things, Julie has money. She runs the checking account.
For those of you guys that are watching, if you were given a letter
a car.
By
she can take the kids when Mark is at work.
Said, don't open this unless something happens.
Watching her every move.
In the comment section, would you guys
She doesn't ask her son David for help. He's there with her. He's 8. He's young, but he can get help. She doesn't contact her own family. Her own family, Paul Griffin there in the yellow shirt, he lived in the community. She didn't call him. She did talk to Paul's wife, Jill, 5 to 7 days before she died. She talked about how angry she was at Mark. Angry at him. Thought he was having an affair. He was out carousing. Thought he was drinking, socializing with the people he worked with. It was anger she expressed. She didn't ask for help from the people in the community. And her brother, Pat Griffin, she talked to on the phone in late November, about a week and a half before she died. And they talked about him buying her car, which he ultimately did. She said, I'll sell you my car. Didn't ask him for help. Was Mark having an affair? Yes. The way to handle that? Divorce. There was nothing here for him to act upon. Julie Jensen did not want or need help because she poisoned herself.
Different. Those are military letters. I mean, that's to be expected, right? That almost becomes moons and goochers. If you open that letter, then something's going to happen. But
there was
more like in this type of
maybe
scenario.
She talked herself out of it when Officer Cosman came over. That was on November 24th.
Says, don't open
November
this
25th, she told Ms. DeFazio. The following weekend, she was telling Mr. Voigt, I can't eat, I can't sleep, I won't eat, I'm scared, I'm going to be poisoned. There was no talking out of it. The evidence will show she maintained her delusions and her desire to take her own life throughout. Now I'm basically done. I will present evidence in this case through cross-examination and I can almost guarantee I'll call witnesses in this case. But as you know, this is a long trial. It may be a very long time before I call my witnesses. So you may hear a state's witness that there's contradictory evidence to, but you won't hear it for weeks. Why am I telling you this? I need you to keep an open mind. I need you to hear all the evidence. I need you to wait and hear it all. And then at the end of this case, we'll see Mark here did not kill his wife, Julie. Thank you.
Well, that was the defense's opening statement. So if you guys are, happen to just be tuning in, the first half of this stream, we played the prosecution's opening statement from the original 2008 trial. So you got to hear both. You got to hear the prosecution. The prosecutor that you saw in that was, is it Robert Jamboy? I believe his name is Robert, right? Robert Jamboy. He'll be returning for the retrial. And kind of got a little bit of idea maybe on what we're going to hear. Opening statements are expected to start tomorrow morning. I'm not seeing anything that a jury has been seated in this case yet. Keep trying to update to see what's going on, see if a jury has been seated. They were hoping to have jury figured out by noon. And we're not getting any updates yet that they have finalized it. Once again, we posted the letter, the so-called letter from the grave. That is not allowed to be used in the retrial due to it originally violating Mark's Sixth Amendment right to confrontation. That letter is up on our Facebook page. You can get that. There's some links in the chat here that can bring you over to the Facebook. We posted the original criminal complaint on the Facebook page. We did a stream yesterday where we played some old archive footage and kind of talked about background of the case, background of the Supreme Court rulings and all of that. We also kind of talked about the change in the confrontation rule that ended up leading to this, but kind of how that started and how that ended up changing and all of that. So we talked a little bit about that. We found a website for Jensen's legal defense. We're not sure who built the website. It's pretty archaic. Definitely looks like, 90s kind of built website. I doubt it's the legal team. There's a lot of opinion stuff in there. It did give some factual background, but I don't know, kind of hard to believe that maybe an attorney built that page and wrote those things. But it was interesting enough to read. Arm says, I wonder if defense will change their argument because Julie's statements aren't allowed to be used either. I think framing him seems harder to prove than simple unaliving herself. Yeah, maybe. I think that, I don't know, the letter part is interesting. I don't know, the letter just seems, there's a few things in the letter that seem very suspect to me. Hearing the defense again, today, talking about how she actually has medical background. So she would have had knowledge of these different things that they're putting on Mark Jensen. So that, that kind of changes the perspective a little bit. she obviously, had access to certain computers. There was one part in the state's opening, which I guess kind of refutes the thing where, she could have been, researching this stuff online to, again, kind of frame him. But it was interesting, the fact that he was looking at stuff on the computer at work. And after somebody had mentioned, a colleague had mentioned, oh, I'm surprised the police didn't take your work computer. And then all of a sudden, his hard drive, basically malfunctions on the work computer. So that kind of made me question some things, as to his actual guilt. So a little bit of back and forth. I'm not 100% convinced one way or the other. Again, knowing one of the original attorneys, because she was my attorney for Kenosha unlawfully arresting me during the Kenosha unrest. I was the first journalist to be arrested in Kenosha for filming, which, is pretty fucked up. But again, knowing her, she was pretty excited that Jensen was going to get this retrial. And again, she didn't disclose anything to me because she can't, but just from her demeanor and everything, to me, I felt that she thought Mark was legitimately innocent. I trust her, trust her opinion. Again, obviously she can't disclose details or anything to me. So, obviously we don't know 100%. I am going to reach out to her. Like I said earlier in the stream, I'm going to see if she's, able to come on and talk. If she's willing to. She's kind of a pain in the ass to get a hold of. Not sure if technically she can or not, but, we're going to try. We're going to reach out and see if we can get an interview with her for you guys. Be interesting to hear. So, but either way, this case is going to be pretty interesting. Even the tactics that the legal team is going to use, from 2008 compared to how it's going to be handled now. Wondering if Jamboy's opening statement is going to be similar to what we heard in the 2008 version. He seemed very calm, very just kind of matter of fact in 2008. In some of the pretrial hearings that we've seen, Jamboy seems a little bit more aggressive. So it'll be interesting to see if he's going to be more aggressive during his opening. The fact, again, that, there's witnesses that are unavailable, either deceased or are suffering from dementia. So using Court TV's archived footage to show their original testimony with some redactions and some editing, because there's certain things that were talked about in their testimonies that are not allowed to come into this retrial. But that's going to be interesting too, in how that's played, how that's challenged, objections now. So a lot of that stuff's going to be pretty interesting as well. This is definitely going to be, a pretty interesting case. There's a lot of attorneys, we're going to start seeing a lot of lawyers doing breakdowns on this case all over the internet. So it's going to be interesting to see what they have to say. So I'll be watching some of those breakdowns, after each day, see if maybe we can get a little bit of an insight. Obviously, during the actual trial, we're not going to be talking over, what's going on like we were in these last couple of streams. We were kind of talking over some stuff. I was trying to do that, a little bit due to copyright stuff, but just to kind of talk to you guys about what's going on. We're not going to be stopping the trial and answering questions and pausing. I'll be typing some answers to you guys if I can, but we're going to play the trial all the way through. I want to say, so tomorrow's Wednesday. Opening statements are expected to start tomorrow. Thursday, there is supposed to be a hearing for the Idaho murders. with Brian. I don't know how to say his last name, Kopberger or whatever, however you say his last name. So I think what we'll do, because I'm not going to stop the Jensen trial to switch over to that. That's another high profile case. I'm sure when that case actually happens, the Jensen thing should be done with. And provided that, this ends up being worth my while streaming this case, maybe we'll cover that case too. But I think what we'll do, since he has a hearing on Thursday, so we'll continue with the Jensen trial, and then during a break, because I think his thing, we posted it up on the Facebook page, but I want to say his hearing was rescheduled to 8 or 8:30, so probably around the same start time as the Jensen thing on Thursday. So if it starts before, we'll stream some of that and then switch over to Jensen. If not, we'll cover Jensen and then play the Idaho hearing during one of the breaks. And that'll take up some of our downtime there. During breaks and things like that from the Jensen case, we'll play some archive footage. We'll talk. We'll answer some questions. We'll show the letter. We'll show some behind-the-scenes things that are going on. And we'll keep you guys updated in that respect. So, like I said, we did do a stream yesterday where we showed some archive footage, gave some background details on what was going on in the case. So make sure you guys check the YouTube channel out for that. And tried to give you guys as much information as we could, kind of get you up to speed for those that don't know about this case or are, aware of it, but are kind of unfamiliar with some details. So hopefully that gave you guys a little bit more of an insight in what we can expect to see from this trial. So make sure you guys like the stream here. Make sure you're subscribed to the channel so you know when we go live. And for Facebook, make sure you guys like and follow the Facebook page. We'll be doing some updates on Facebook. We're going to try to live stream on Facebook and YouTube. But last night, I tried to do a live stream and I was having some issues, which is why I didn't live stream this on Facebook today. And it was just on YouTube. So I don't know, maybe we'll try it on both. If we're running into issues, then we might just stream this on YouTube. We'll have to see. Yeah, I mean, according to Jamboy, in an interview that he did some years later, I think that as this case was bouncing, in and out of, courts, he had made comments. He's made public comments that basically he doesn't really care about the letter. The letter wasn't the damning piece of evidence that, convicted Jensen the first time. They felt that they had a lot of other convincing evidence. Even jurors from the original case that were interviewed publicly said the same thing. When it was decided that there was going to be a retrial, some of those jurors were interviewed. They were kind of outraged that the courts, denied the letter and allowed for a retrial. That's obviously, some misunderstanding of, how the laws and system works, but whatever, rightfully so, they're allowed to be upset. But even those jurors that gave public interviews said that, when they were deciding the case originally, the letter wasn't the one piece of evidence that was damning to them. So it's interesting because you guys will see all over media, right? Lamestream media is so focused on this letter, which, I mean, rightfully so, right? It's what overturned the case. But they are so focused on the letter that this letter was the damning piece of evidence that convicted Mark to life in prison without the possibility of parole in 2008. And, according to Jamboy and according to original jurors, the letter didn't play that big of a, influence into their decision. So, but Lamestream media is saying that it was. So we'll see what happens. It's going to be interesting, nonetheless. It'll be an interesting case. For WTD, so during this stream, we kind of had to interrupt the stream for a press conference. I'm going to put that press conference up on YouTube once I'm done with this. But basically, WTD B. Ivory Lamar filed a writ of mandamus lawsuit against Milwaukee due to some open records request denials. Sounds like a really screwed up case. But I posted the mandamus document on the Facebook page, but I'll put up the press conference so it's separate from this, even though we live streamed it in the middle of this. But WTD, you're probably going to want to watch that. That's interesting as well. I'm sure you'll have an opinion. For those of you that don't know WTD, what's the difference? He is not an attorney, but he is in law school and does some legal stuff. So it's the closest that we have to, a lawyer giving us the breakdown. So if you see him in the comment section commenting about law stuff and whatever, he'll hashtag not legal advice. But some people like to jump on him, and don't do that, because he's just trying to basically dumb down what the law means for us uneducated people that, don't have a full understanding. So he may be in and out of our streams as we're covering this case, and he'll break down some legal meanings for us like he does on all of our streams. So hopefully we can get him in here a lot, because that was good during one of the other trials we covered. Yeah, I'll stay on here for another minute or so, and then I had to get to getting this press conference up on the channel. I was advocating in court yesterday. Right on, brother. That's awesome. Very, very cool. Once again, guys, make sure you guys are subscribed to the channel so that you know when we go live. Make sure you hit the bell and click on all notifications, so you know when we're uploading videos, when we go live. Like and follow the Facebook page. There's links that are in the chat that'll bring you to the website where we post our articles. There's a couple of articles that we're highlighting. One on Judge Doro, who handled the Darrell Brooks case. He's the guy that drove his SUV through the Waukesha Christmas parade out here. We found out some things about Judge Doro that are not very flattering, and not the person she, publicly claims to be, nor is her campaign manager. So give you guys a little different perspective on her. So that's been going through the chat, and then this viral TikTok that we've been covering. There's 3 articles up on our site, but we have linked the 3rd article. So be sure to check that out. The website is Never.Stop.Voices.com. You can read about the articles. If you're new to the platform, I'm an independent investigative journalist here in Southeast Wisconsin. We do a lot of civil rights kind of journalism and exposing corruption within systems. It's kind of our main focal point. We do cover some other stuff, but we really like to investigate things. Most of our investigations do take several months. I was in Kenosha when all of that went down. I was on the street when Kyle Rittenhouse opened fire. I watched Anthony Huber get shot and killed right in front of me. I live streamed. You can find our live streams on the channel. We are the only media company that has released the most content, documents, as well as video of the Kenosha unrest. That investigation has obviously taken us 2 years, and we are still continuing to go. We have filed open records requests on 26 of the 51 law enforcement agencies that were out there. We still have 25 other agencies to file on. So there are some links if you guys want to donate. It helps pay for records. We spent thousands of dollars of our own money obtaining records, and with the help of you guys, we've been able to get some other things. So there's some links for that as well. But yes, you can find hundreds of videos on our YouTube channel here of body cam videos from law enforcement during the Kenosha events, courthouse camera feeds that show obviously a very non-biased version of what was going on. There are some things real quick, because I did want to kind of mention about the press conference that we all watched together. So, like they were saying in there, we do have a state law here in Wisconsin that the shooting agency is not allowed to investigate themselves. State law prevents that, and they have to be investigated by a different agency. Those agencies normally are working together anyway. It's normally a neighboring department. And there's a lot of really screwed up things when it comes to that. A perfect example of that, a former Wauwatosa police officer named Joseph Mensa shot and killed 3 people in a 5-year period out here. And the second shooting that he was involved in, where he shot and killed Jay Anderson Jr., there was a big investigation, a very unprecedented case that happened out here. It was a John Doe hearing. It's the first time that it's happened here in the state of Wisconsin towards a police officer. We had multiple hearings on that. It's basically, an attorney that represents the family presents evidence in front of a judge, and the judge decides if there's probable cause or not. And a Milwaukee County judge found that there was probable cause to charge Joseph Mensa in a negligent homicide of Jay Anderson Jr. Special prosecutors were assigned to that case and declined to file charges. Mensa resigned from Wauwatosa, and he's now a Waukesha County sheriff. So the same city that you guys are familiar with, Judge Doro in Waukesha. Mensa is a sheriff out there. So, we have videos of that. We have articles posted, on that stuff as well. But with Wauwatosa in general, we did a deep dive investigation. We have a 3-part live stream documentary up on the YouTube channel. It's the MLK Party live streams. You can find that in the playlist. Basically, in the late 80s, early 90s, Wauwatosa PD was holding racist parties on Martin Luther King Day. And we did this deep dive kind of history with Wauwatosa Police Department and, some racism within the system and kind of how Tosa, kind of behaves. And there's it explains how policing happens when there's, shooting events, and you hear about law enforcement being put on administrative leave, and then you hear how they're promoted. We go through all of that, how and why they're promoted. Everything is about protecting the city's image and money. And we also implicate Wauwatosa PD in some very, very serious crimes. So 3-part series. It's kind of heavy. It's pretty deep stuff. But there's a lot of really cool content on our YouTube channel. So we are not the type of company that puts out little soundbite clips. So you'll find a lot of videos that are very, very long, 12 hours, 13 hours, 15 hours, 19 hours worth of boring ass video. We do that on purpose so that there's not a narrative, and you guys can see what actually truly happened during a situation. So obviously some of those videos, you fast forward through some of it. But there is a lot of really interesting content. Our articles, we do tend to write a little bit more lengthy than you find with lamestream media, because we're trying to get you guys as much detail as possible. But we try to, make it a little bit concise so it's not so fucking crazy for you. I do cuss on the channel. If you have a problem with that, oh well, too fucking bad. If you don't like the naughty words, go read the articles. We don't use naughty words in there. We invite everybody on here. You're more than welcome to have a difference of opinion. Just be respectful to each other. If you're not, then, we start banning people and all of that. But so far, you guys have all been great. And, we want everyone to stick around, and we want everyone to know the actual truth about situations. So that's what we do here. JK says, I'm so glad you put a spotlight on all of that. It is kept in the dark in many departments. Yeah, it's that MLK stuff, and that's the thing. Like, so that obviously focused on a police department out here, but it really gives a very clear understanding of how law enforcement works. And it's not just here, that's in all these cities, all these states, all of that stuff. So, on the website, we've got, let's just pull this up. Let's check it out real quick. I'll just run through some stuff with you real quick, and then I got to get off here. I'm exhausted. And I don't want to bore you guys too much. Let's see. All right, so this is the website here. Okay, this is what it looks like. So I'll just kind of run through. So our TikTok stories are up here. So we have 3 articles that we wrote on TikTok. Basically, the first article talks about this TikTok story of sexual intercourse with a child. And here we are 9 years later, and this girl named Savannah is telling her story. The first video got almost 600,000 views. All 3 of those videos are up on our YouTube channel, so you can actually watch them, because the second article that we wrote, a judge has put a court order forcing her to remove her videos, which could be argued that it's a violation of her First Amendment right. And then the third article that we wrote on the TikTok story, and please share this, because this needs national attention. This is not, it happened here in Wisconsin, but this really needs national attention. The third article, we really revealed that the Fond du Lac County District Attorney, Kristen Menzel, who handled the case, filed a motion with the courts to dismiss the case. And what we found out through open records requests in our own little investigation thus far is that this DA, Kristen Menzel, intentionally lied to the judge that was presiding over this case, and it got the case dismissed. There's a lot of really fucked up things happening with this case, where documents are now missing from court files. Convictions for this individual are not up on our public system. There's no transcripts of court hearings, videotapes, body cam footage, interrogation videos. Shit is just missing from these fucking files. So, we're digging a little bit deeper on this. We're not done with this story, but this is the kind of stuff that we do. And it's because of this DA that this girl was not protected. The doctor that originally saw her for a pregnancy, because she's had 2 children with this individual while she was a minor, 15, 16 years old. The doctor, who is a mandated reporter, did not report this. And we just found out that allegedly the doctor was a family friend of the guy, and the doctor also forced his nurse not to report this either, something that we just found out a few days back. So yeah, please read the TikTok articles and please share them out. And then, like I said, we have Judge Doro. So we found out that Judge Doro's campaign manager is a far-right extremist. So some very far-right, radical fucking views. We're not just talking about Republican or conservative. We're talking some serious far-right fucked up shit. And contradictions in statements that Judge Doro has made in her interviews. She is not the judge that she claims to be. She is not the judge that claims that she is for everybody's rights. She is not. She is a liar. She is going for Wisconsin Supreme Court. So her campaign is going, and that vote will come up in February. So, you know, the Darrell Brooks case was, you know, national. Everybody was talking about it. Doro is the judge that handled that. And, yeah, so we kind of exposed what her actual belief system is, and it's kind of dangerous that she shares some far-right extremist viewpoints. I actually liked her as a judge, even though she was, you know, conservative judge, Republican judge. She seemed like she might be okay. And, you know, we dug on some shit and found out that it's probably not the right judge for us out here in Wisconsin. Another interesting story that we have up here, you know, if you guys watched all the protests and riots and things that happened around the country in 2020 and into 2021, I'm sure you guys heard a lot about Antifa. And what we found out is that the director of Homeland Security, who was brought in by President Trump, that they manufactured Antifa claims in order to create widespread panic throughout the country in an effort to get Trump reelected for a second term. So a lot of the Antifa shit that you guys were reading about from right-wing media was fake. So we actually have documents that were leaked by a, I don't know, it was either Portland or Seattle senator. It's in the article. You can read the documents. They're linked in there. We did this other article, basically, you know, starting from the Cold War, the propaganda, which helped shape modern society today. So a lot of that right-wing shit that you guys were buying into, you know, kind of gives you an explanation. I really did it for the people on the left so that they had a better understanding of why people on the right think the way that they think, especially during pandemic, Trump era, things like that, conspiracy theories. You know, and I've said on this platform before that some of the shit that the right says is not bullshit. It's actually true. And even some of their conspiracy theories have underlying truth to them. Who the fuck knows how they got to so far out there. Covered the Waukesha Parade thing. Some of you may know a live streamer, CJTV. You know, we expose dishonest fucking scumbag live streamers as well. This individual filed a restraining order against me that was defamatory and false light. Lied about a lot of very serious allegations. Cost us a little bit of reputation and integrity issues, but ultimately we won the case because he's a lying fucking piece of shit. If you want to know about Kenosha, so we've got some articles in here about Kenosha when it comes to how prepared Kenosha was for a riot. That's a really good article to read. It explains a time frame on when decisions were made. This is based on thousands of documents that we've received through open records. So when you guys donate money, that helps us pay for those things. And then the 13 hours, the ignored militia threat, where law enforcement was focusing on protester bullshit that they couldn't corroborate and ignored for 13 hours. A bunch of violent militia and right-wing bullshit that they were actually able to corroborate, and they ignored it, which is what led to violence in Kenosha. What else? Let's see. some other really cool stuff. We exposed some cops for being scumbag pieces of shit. Challenge coins, that's a great article to read. We're investigating a possible scenario that there was a fourth victim in Kenosha and it wasn't just 3 people shot that night. There's some pretty damning evidence for that. There's a couple articles, plus we have a video up on the page. There is some outdoor adventure style content on the platform, whether it's an article or a video. I'm a long distance hiker, so sometimes I can't just be talking about sad, depressing shit all the time. And, you know, I got to get out in the world and go get lost in a forest. And I tell you guys about that stuff too. What else? All this like rush to justification, things like that. Those are the Joseph Menta articles. We talk about our lawsuit. We sued Kenosha for things. You know, we're very transparent on this platform. Very transparent. I'm transparent about me, my life, my background, stupid shit that I've done in my day, bad things I've done in my day, whatever. This is a great article, Insurance Policies. This is going to explain to you how law enforcement is insured. It really explains budget money and basically how you, the people, are getting absolutely fucked, and you end up paying for police. So for all of you that, you know, are like clapping fucking hands together that black people are getting murdered by police, you know, you end up paying for that shit. And that's a great article to read. What else? Kenosha's ALPR grant. This is another one. So, you know, when law enforcement tells you like, oh, we need to put in these automatic license plate readers, we need to buy this dumb, expensive equipment that's going to be for your safety. It's not. It's a bunch of bullshit. This article that we wrote ended up blocking a $49,000 grant in Kenosha for automatic license plate readers. They're not good. They're dangerous. They're a violation of people's rights. And this is a great article for you guys to read. For those of you that, you know, support law enforcement, that's awesome. Find a fucking better way to do that than flying a blue line flag. That's some racist fucking shit, and it supports brutality. So this article, we don't need lines, we need unity. This explains to you the history behind the blue line. Find a better way to fucking support law enforcement. I'm all about that. Let's get the shitty cops out of there and get some good cops, you know, so they're not in danger. We do write some, you know, opinion pieces. I kind of write about my experience through all of this stuff too. So those of you that think independent media is fake news, we're not. This is a great article that explains pretty much what the fuck we have to go through. If you want to cry, these 3 articles here, Seeing with Brand New Eyes. This is kind of my experience of seeing the world through a different lens. Is it worth it? This is a very left-leaning article about an experience I had, a beautiful moment I had with a little black boy that I met. And I was questioning whether my journey through all of this and getting death threats on a daily basis was fucking worth it anymore. This is a great story. This will make you cry. If you're on the right, I have a story of a beautiful moment I fucking filmed, filming some right-leaning crazy shit. And I had a beautiful moment, and that's in the one girl's dream. This little girl wanted to be a journalist. So yeah, that's pretty much, you know, a little breakdown. Obviously, we didn't talk about every single article that's on here, but that's a little breakdown of that. So that is that, everybody. Anyway, I'm out. I'm done. I can't talk anymore. I've had way too much coffee, and we got to get some rest for tomorrow morning. Opening statements, Mark Jensen trial 2023. JK says, awesome work. Thanks, homie. All right, guys, I will see you later. Thanks for tuning in. Be sure to like, subscribe, and share, and we'll catch you guys later.